Good afternoon. We have almost 7.5 hours of argument time requested. Please ask for the time that you need, not the time you wish. If we keep having questions, we will keep asking them. People versus Bay, appellant? Respondent? 4, 1, and 4. Vines versus Judo contracting? Respondent? 5, 2, and 5. Alcantara versus Toro, appellant? Respondent? 5, 1, and 4. Haygood versus Prince Holdings, appellant? That is submitted. U.S. Pony Holdings versus Fashion Footwear. We have 2 appeals that are going to be argued together. So we'll just do them. Well, appellant goes first.
You want separate times for each appeal? Or?
No. We're going to argue them together. So you have to get everything in on one argument. Respondent? I'm going to give you each 8 and 1. If we have more questions, we'll just keep asking them. I understand it's complicated. People versus Samson, appellant?
Appellant request 10 and 2.
Respondent?
10 minutes, Your Honor.
I'll give you 7 and 1 and 7. Again, if we have more questions, we'll keep asking. Groutton versus 553 Marcy, appellant?
5 and 2, please, Your Honor.
Respondent?
3, Your Honor.
5, 2, and 3. Arajen LLC versus Tapjets Holdings, appellant?
Good morning, Your Honor. 8 and 5.
Respondent? 7, 1, and 7. You have a cross appeal. Do you want? Okay, 7, 1, and 7. And again, if we have more questions, we'll keep asking. Rosario versus Montafure Medical Center, appellant?
6 and 3, please.
Respondent?
9.
6, 1, and 6. Rivers versus Panama Leasing, appellant?
5 and 2, please, Your Honor.
Respondent?
Respondent 6, Your Honor.
5, 2, and 6. Agüero Salatte versus Brealey School, appellant?
Appellant request 4 and 1.
Respondent?
I guess cross appellant, Your Honor. We request 4.
4. And who are you representing?
Plaintiff respondent 5.
Taro versus Amade, appellant? Respondent? 6, 1, and 5. People versus Santos, appellant? I'm sorry, I can't hear you. Respondent? 6, 1, and 6. Gordon versus Martell, appellant?
Appellant 5 and 2.
Respondent? 5, 2, and 6. And State Farm Mutual versus Taurus is submitted. So our first case is People versus Bay.
Good afternoon. My name is Lorraine Medell, and I represent the appellant Nami Bay. Ms. Bay's plea was not voluntary, intelligent, knowing because the court did not sufficiently inquire.
Could just put the microphone close. I'm just having a little trouble hearing you. Is your microphone not on?
I don't see a green light, but I don't know what to do. What do I do?
Okay. Go ahead.
Okay. Ms. Bay's plea was better.
Yeah, just speak in front of the microphone. That might help.
Okay. Ms. Bay's no, this way. Ms. Bay's plea was not knowing, voluntary, and intelligent because the court did not sufficiently inquire as to whether or not she was competent at the time she entered the guilty plea to enter that plea. This incident arose from a psychotic episode. She had previously been examined by 2 court-appointed psychiatrists who, although they found her competent at that time, warned that she may become incompetent if she did not comply with taking medication. They thought that perhaps she was competent then because she had previously been, against her will, injected with medication during a hospitalization, and they thought perhaps that medication was still in effect.
Counsel?
And very importantly,
I'm sorry,
one of
she has
the
a question for you.
symptoms, I'm sorry.
Can you tell me how you get around the preservation requirement?
This is a case that does not require preservation. There are exceptions, obviously, to the requirement of preservation. But here, when you have someone who is questionably not competent to answer the questions of entering a guilty plea, she cannot be obligated to then preserve it. It's akin to the fact that even if the waiver of right to appeal had been valid,
Counsel,
this type of challenge.
What's your best argument that she was unable to understand the proceedings or to assist in her defense at the time she took the plea?
I'm sorry?
What's your best argument as to why she was unable to understand the proceedings at the time she took her plea?
What I'm saying is that we don't know that she was competent. She did, okay.
Was there anything that happened? I mean, she'd already been found competent twice by two
Yes.
hearings. So is there anything that happened at the proceeding which supports your argument that she wasn't competent?
When she answers the question right at the beginning, when the court says, "Are you pleading voluntarily?" and she says, "Because I'm under duress and coercion." Okay, that should have raised questions in the court's
Counsel,
mind.
could that response have had anything to do with her own, like, political perspective?
We don't know, and that's why the court should have inquired further. It could have been, it just was that she felt that way. It could have been a symptom of her mental illness, because what had been
And why
documented.
couldn't the counsel have raised that at the hearing? If he thought the court was not doing a sufficient inquiry, or she, why didn't the counsel have the ability to raise that at the hearing itself?
Whether or not, because the court, and recently the Court of Appeals has reaffirmed in People v. Scott, which we cited in our reply brief, whether or not, whatever counsel's obligation was, it's the court's obligation to ensure.
There's a preservation
guilty plea.
requirement, so it goes to preservation. You
As
have to do
opposed-
something to preserve it. You have to make an objection or do something to state that there was a problem with what happened, or move to vacate the plea below, none of which happened.
Yes, and what we are saying is that this type of challenge in this particular case did not require preservation. If the court finds that it requires preservation, we would ask that the court reach it in the interest of justice. The
Thank
most.
you. I'm going to give you, you have time in rebuttal. Thank you.
Good afternoon, Your Honors. Michael Tarpon for the people. Your Honors, it is true this claim is unpreserved. Counsel had every opportunity to make a motion to withdraw the plea, as has happened in many cases before this court. In our brief, we cited the many cases where this court has held that a challenge to the voluntariness of a plea must be preserved, even when based on medication noncompliance.
Wasn't there a month time between the plea and sentence? There was ample time to do that, correct?
There was, Your Honor. It's not a LaRue situation where the sentencing happened at the same time as the plea. So there's ample opportunity to preserve this. Further, Your Honors, the claim simply is without merit. The court here specifically inquired into the defendant's medication compliance, and under these facts, it had no obligation to do more, especially since the defendant's own expert had concluded the defendant was now medication compliant. She was amenable to taking her medications. She, in the words of the expert and of the social worker who was very involved in the defendant's mental health care, she was amenable to taking her medication, and she was committed to cooperating with her treatment. So medication compliance is essentially no longer an issue here. But even so, the court went beyond the CGI model colloquy and asked about medication compliance and said, "Are you taking the medications you're supposed to be taking?" And the defendant said yes. That basically is a situation is not unusual. It's a simple credibility
What
determination.
about the argument that the court had some obligation to do a more searching inquiry as to a competence after there'd already been 2 examinations?
I believe there was one examination, and then counsel retained an expert for the defendant.
Right,
for
so
the
that made
second
2
one.
examinations.
Right. But there wasn't a second. I believe that's correct. There wasn't a second incident to cast doubt on.
No, I'm just saying there were 2 examinations.
Right.
So there was obviously some issue
Right.
with the defendant's competence, and under those circumstances, what about the argument that the court's inquiry was not searching enough?
Here it was. Again, the second the defendant's own expert was assuring the court the defendant is amenable to taking medications, and that she discussed that at length in her report. As
Counsel,
yes.
was there anything that took place during the colloquy that would have raised the court's concern to probe further as to whether or not the defendant was competent?
No, Your Honor. The two things that the defense relies on in the brief, neither of them would raise an issue as to voluntariness. The first is this issue when the court says, "Are you pleading guilty voluntarily?" She said, "I've been arrested and coerced." That's essentially, to me, looks like a situational coercion claim. I don't want to plead guilty, but I don't want to go to trial and be exposed to a higher sentence. So, yeah, I'm coerced in that sense to plead guilty. That's not coercion in the sense that we're talking about coercion. And the second, of course, is when she talked about her abolition name, Nami Bay, and her expert went to great length explaining in her report that that's a Moorish American cultural identity that does not indicate any kind of delusion or any kind of lack of competence to plead guilty.
Now, at any time, did either defense counsel or the defendant say, I don't understand, I have an issue with what's going on, I need further explanation? Did any of that take place?
No, in fact, the defendants assured the court that she did understand the proceedings. The court followed, in substance, the CJI model colloquy and was asked repeatedly in different ways, "Do you understand what's going on?" And she said yes. Further, the attorney here was very much involved in this case and knew very well about the defendant's competence. She was the one who had asked for the 730 examination. According to the report, she was there in the examination, representing the defendant during it. She retained the other psychiatric expert. She retained the social worker. The counsel here is very much involved in this, and she presumably was competent that the defendant was competent to plead guilty. So
essentially, she considered the defendant's illness a factor possibly to mitigate, but not a factor that would make her incompetent to be able to take a plea, correct?
yes, Your Honor. And that's when she wrote a letter to the plea court submitting the expert report and the social worker's letter. That's the argument she made. That's the argument she made 9 days before the guilty plea, when she wrote a letter to the DA, filed it with the court asking for the same thing. You should give the defendant a better deal because of this, because she's committed to cooperating with the treatment. She's amenable to her medication. That was the pitch, that if you give her a good deal, it won't be wasted. She's going to cooperate with treatment.
Thank you.
Thank you, Your Honors.
First of all, we're not sure whether or not the court reviewed the recommendation or the letter from the defense counsel, because there's no indication during the plea colloquy that the court referred to it. What we do, and even that just said that Ms. Bay was amenable to treatment if she received medication for PTSD, not for the bipolar I disorder, which what the two court-appointed psychiatrists had said was there was a symptom that she would deny that she needed medication for that bipolar disorder, and that she did deny that she needed it. So when she answers the questions, when the judge says, "Are you taking medication?" and that second question was very poorly worded, should you have been taking medication that would affect your ability to answer? The person who's answering that question is a person who doesn't believe she needs medication. So her answer is not a reliable indicia as to whether or not she is competent to plead guilty.
Thank you. Thank you very much. Vines versus Judo contracting?
May it please the court, John Newman for the appellants. In this case, the lower court wrongly granted summary judgment to the plaintiff and also
Counsel,
denied.
would you kindly lift up the mic?
I'm sorry.
Thank you.
Better? Okay. In any event, John Newman for the appellants. In this case, the lower court wrongly granted summary judgment to plaintiffs and also denied summary judgment to the defendants. The particular case focuses on a construction accident where allegations involving 240, 241.6,
So
and
we're
200.
familiar with the case. The main argument you seem to be making is that plaintiff's responsible for the accident because plaintiff was standing under the hoist, and therefore plaintiff was the sole proximate cause. It was a recalcitrant worker. But we have numerous cases where we've previously held that even if there was some part that plaintiff played in the accident by being in the wrong place, that at most is comparative fault, which doesn't defeat summary judgment. So how do you get around that legion of cases and distinguish it, which hold that this would just at best be comparative fault, which would not defeat summary judgment?
Understood. Fair points. Your Honor, in this particular case, summary judgment should have been granted to the defendant and also denied to plaintiff because there were adequate safety devices involved in this particular case.
How could they be adequate if they didn't stop the brick from falling? I mean, I understand there was a net, but how can the net have been adequate if it didn't prevent, if it was adequate, then the brick wouldn't have fallen through the net and hit the plaintiff?
Well, all of the cases that the court's referencing, Fromel, Mercado, Mallorquin, Padros, Hill, all are situations where there was no net. Here there was a net that had been inspected that
Counsel,
day.
in Mallorquin, there was an unsecured brick that fell on the plaintiff where the netting proved inadequate. So there was netting in one of those, at least one of those cases.
But inadequate because it wasn't on that side of the building.
What does it even matter? I mean, the standard is the protective device sufficient to protect plaintiff? And if the net can't stop bricks from falling through, how can it be adequate as a matter of law?
Because it had been inspected that morning, there was nothing wrong with it. It was understood, this wasn't a situation where there was a tear in the netting. It was understood that the netting, in order for the bricks to be transferred, needed to be opened, and it would be opened, and the plaintiff himself knew this as the competent person on the project, the qualified person.
You're saying even though the netting was inadequate, we should find it to be adequate? I'm not sure what.
Well, no, it was an adequate safety device. It was an adequate safety device that the plaintiff knew was adequate. What he also knew and had been told many times before and also on the morning of his accident that he cannot stay in the
That goes to the comparative fault, not to the issue of whether the safety device was adequate. I mean, I don't know how you can argue it's adequate when it didn't work.
It is adequate. The plaintiff did not afford himself of the adequacy of the device.
Well, my understanding here is that this was an external hoist. The records show that there should have been a catch platform. There wasn't a catch platform there. Everyone claimed that the brick tong, where he went to take the bricks, what they call misfired, based on the parlance, and the brick fell. So, and I understand that the plaintiff had to operate the hoist, which, while at times everyone may not have been able to be in that zone, he had to be in order to get the bricks into the hoist and up to the 5th floor platform area. So under those circumstances, I really don't see how you get around how the netting, the existence of the netting in and of itself is an adequate safety device.
The netting was adequate. The hoist had already stopped. The plaintiff should have and could have left that area where he was struck with the brick, but he chose not to, and that's the purpose
Counsel, here's a problem. Who is it? Mr. Dominic Stiller, the principal for DES&Y, the entity that drew the scaffold drawings, right? He testified that the drawings included a rail-mounted hoist that operated within the bay of the scaffold, and he said that this hoist, which was an exterior-mounted swing arm, was located outside the netting and posed a danger. How do you get around that? How can you argue that summary judgment is appropriate where you have that kind of testimony?
because every construction project changes during the course of the entire project. And just because the hoist was on the outside rather than the inside is of no issue, because if plaintiff had afforded himself of the safety device that was in place in terms of the netting and had exited the hoist area after it had already reached its destination, there would have been no accident. And
I'm going to let you give any additional response.
Thanks so much, I
Thank you.
appreciate it.
Good afternoon, Your Honors. May it please the Court. Lisa Como for the plaintiff respondent.
Counsel, the industrial code states that an exterior face of a wall, such as the wall in question, required a catch platform. Is there any exception that would be applicable here?
No, I don't believe so, Your Honor. I think that the exact wording of the regulation is it has to be of like an equivalent strength to a catch platform. There's been no proof that the netting, even if it actually had functioned, was of that equivalent strength. I believe that under the regulation, that's the 2.6, sorry, 6.13 H. That absolutely was required. I mean, he was the hoist operator. If anybody had to be in that area, it was him. There is a slight difference in the testimony as to whether he said that he was coming back with additional materials. There's an affidavit from the foreman who says, no, he was standing under the hoist. Exactly where, we don't know, but we also know that that hoist is operated with a remote control. It's like on a wire. So it should have been configured properly with a platform overhead or something of equivalent strength and function. Perhaps the netting could have been used. The netting was designed, as the engineer testified, to surround the hoist, because the way they erected it with the hoist on the outside of the netting, it wasn't prone to just hitting someone who was standing immediately underneath. It could fall out and hit anybody who was passing the area. That's clearly not the intention. The netting is supposed to keep it contained, keep it in. I don't believe there's any way to validly distinguish this case from the numerous cases cited in our brief, like Mayorquin and Hill, where virtually identical circumstances are presented, where the same arguments are made concerning sole proximate cause, and where this court said, no, any potential disobeying of instructions not to be in the area, which incidentally the plaintiff denied ever receiving any such instructions, and again, he is the hoist operator who's supposed to be there. But even if that were the case, that's at most comparative negligence, which certainly is not a defense.
The record tells us that the brick tongue misfired.
Yes.
Is there anything in the record that tells us that the plaintiff was supposed to do something when he heard the brick tongue misfire, or not do when he heard that?
I don't think, I mean, it seems to me on this record that it's sort of like a split-second kind of an occurrence where he's there, suddenly he hears the sound, and the next thing, a brick lands on him. And the coworker admitted that something went wrong and that it fell from his hands or from the equipment he was using. I don't think there's anything the plaintiff should have or could have done under those circumstances feasibly. And again, even if he hadn't, say, scurried out of the way quickly enough, that maybe that's some kind of comparative negligence, but the cause of the brick falling and the lack of protection to him is the absence of the safety devices. So unless the court has any other questions, we rest on our brief.
Thank you very much.
Thank you very much.
There's no doubt in terms of the record before the court, starting at page 789, that the plaintiff knew that he was expected to use these particular safety devices and that he chose not to use them based upon Mr. Zaman's testimony at 1561.
Does that go to liability, or does that go to comparative negligence?
No, it goes to liability. If there's the existence of the safety device, as there is in this case, and there is not in the other cases that the respondent's counsel.
Counsel, I'm confused by something.
Sure.
I'm not aware that a negative becomes a positive in the context of don't stand under the hoist. That's the safety device. That's what you're advancing, as opposed to a safety net with an opening where a brick is likely to fall out. Well, where is the safety device that he chose not to use?
Well, the safety devices that he chose not to afford himself of was the netting. And the issue is he has a certain degree of competence in his craft. He's the qualified person on this project. He's the competent person on this project. And
How is he not using the netting?
Because he was in the he remained in the no access zone after the hoist had already reached its destination. There was absolutely no reason for him to be there, and he had been told.
Counsel, are we agreed that there was a work safety plan, or it's called a safe work plan, excuse me, that required netting around the scaffold to prevent falling brick? That was the testimony of of Christopher Dawson, the TC Electric president. He testified that JTJ Contracting had hired a safety manager William Spiro to create such a plan, and that plan called for the netting around the scaffolding.
The netting was,
The netting is within the scaffold, under the scaffold, behind the scaffold. Is there compliance with the safety work plan?
I believe the question, well, to answer your question directly, there was netting around the scaffolding. Your Honor's question
Problem
is
is the
really
hoist.
the hoist, the location of the hoist on the inside, depending whether it was a rail-mounted hoist or swing arm.
Thank you.
Thank you so much.
Alcantara versus Toro.
May it please the court, Kenneth Gorman for the plaintiff appellant. There was a conflict in testimony, and granting the defendant summary judgment based on Toro's version of events was improper under these circumstances.
Sir, did Mr. Toro have the right of way under the law?
I believe he did. I mean,
Okay, and it appears to be undisputed that your client was in the bus lane trying to merge into his left, but the driving lane, correct?
That's correct.
And so, under the law, it would be the burden on your client to be able to be absolutely certain that he could safely merge into that lane without being at risk of a rear end or a side swipe, correct?
That's correct.
So why is the court below wrong to dismiss the case?
Well, he testified, the plaintiff testified that he checked his mirrors before switching lanes. He testified that he put his directional before switching lanes, and although he didn't see Mr. Toro's vehicle before Mr. Toro, the front of his vehicle, hit the side of his car, Mr. Toro also testified that he didn't see plaintiff's vehicle also.
Counsel,
Was there
based on how it occurred, though, how could the proximate cause of the accident be anything other than his actions in the way that he entered a lane of traffic from the bus lane? Since he was one who didn't have the right of way, and it's undisputed that the car going forward in the other lane did have the right of way, the total obligation was on him to carefully enter and stay out of the way of any ongoing traffic. So since that did not occur, why isn't he the proximate cause?
There can always be two or more causes of
Right,
the
but why
accident.
isn't he the sole proximate cause based on the way the accident occurred?
Mr. Toro had a duty to see what was there to be seen, and there are issues of fact as to whether he should have taken or could have taken evasive measures to avoid hitting the right side of plaintiff's vehicle with the front of his car.
Wasn't it plaintiff's obligation to not come out until it was safe for him to do so and be totally out in the lane before any other car could approach?
The plaintiff testified that he didn't see Mr. Toro's vehicle before Mr. Toro hit the side
Then
of
he
his
didn't
vehicle.
see what he had an obligation to see under the law.
That's also Mr. Toro's defense, but Mr. Toro's defense is also contradicted by the accident report, which he admits that he did see plaintiff's vehicle before hitting the side of his car. And if he had seen plaintiff's vehicle before hitting the side of his car, there are issues of fact as to whether he could have avoided hitting plaintiff's vehicle.
Is there any
Counsel?
evidence that Mr. Toro was speeding?
No,
And he was within his lane, right?
correct.
He never moved out of his lane.
That's what the record says, yeah.
Right, so I think we
Well,
did a case not so long ago where a plaintiff did not wait until traffic had gone by and it was safe to go in. Partially going in doesn't work. You have to wait until it's safe, and then all of you goes into the lane.
difficulty with this case is neither driver saw each other before the impact. Plaintiff didn't see the defendant didn't see the plaintiff. We just don't know what happened. Under these circumstances, I don't think that you can have Mr. Toro be completely absolved of any of all liability.
Defendant actually testified that he felt the collision before he saw plaintiff's car. That was his testimony.
Excuse me, can you say that again?
Defendant's testimony was that he felt the collision before he saw plaintiff's car.
That can't be reconciled with his accident report, the statement in his accident report where he stated that he observed, he didn't see the plaintiff look, and the plaintiff just cut him off.
Okay,
Thank you.
thank you.
Good afternoon. May it please the court, Patrick Lawless for defendant's respondents. The lower court properly dismissed this case, Mr. Toro was within his lane the entire time. The plaintiff had a duty to wait until there was a complete break in traffic before attempting to
The
merge.
evidence he's saying in the accident report that he saw plaintiff's car and should have tried to avoid it somehow.
None of that matters. First of all, if you look at Mr. Toro's testimony, what he's saying is he didn't see the plaintiff's car because he merged so quick. He just suddenly merged in front of him without any time to react. But drivers such as Mr. Toro, who are traveling within their lane of travel, have no duty. They have a duty to see what's there to be seen, but they have the right of way and they have no duty to anticipate somebody's going to suddenly merge into their lane. They have the right to anticipate.
That's the law. What about the testimony of plaintiff, that plaintiff looked and everything was clear when plaintiff pulled out?
Well, obviously it wasn't, because he contacted, the fact that that there was contact between his car, his vehicle, and Mr. Toro's vehicle shows that he didn't wait until there was a complete break in traffic. The fact that there was an accident, the plaintiff didn't wait until there was a complete break in traffic. This happened on the front driver's side of the plaintiff's car. It wasn't in the rear. It wasn't like he was already in there.
What's your best argument as to the points of collision that it supports your argument?
I'm sorry?
What's your best argument in terms of the points of collisions of the two
Well, the point of
cars
collision
support
is
your argument?
it's like this. Mr. Toro's driving here and the plaintiff goes like this and it's hit right in the driver's side, so it shows that he was trying to cut right in front of him. And again, Mr. Toro has absolutely no obligation to anticipate somebody's going to suddenly cut in front of his lane. He has the right to anticipate that other drivers will follow the law. It's undisputed that the plaintiff attempted to merge in violation of the law. And as previously pointed out, this court just decided 2 months ago a case with nearly identical facts where a plaintiff attempted to merge into a lane and made contact with the defendant's vehicle, and this court found unequivocally that the plaintiff had an obligation to wait until there was a complete break in traffic, and his failure to do so was the sole proximate cause.
Judge Kern and I were on that case.
Oh.
Thank you.
Thank you.
Just briefly, in Kirschgessner versus Hernandez and Kelly versus City of New York, which we cite to on page 17 of our main brief, this court held that a defendant who has an unobstructed view of the roadway and claims that he had never seen the plaintiff before the accident cannot be absolved of liability. At the very least, there are questions of fact with regard to Mr. Toro's liability. He can't be absolved under these circumstances, especially with regard to the points of impact. The front right portion of his vehicle hit the side of plaintiff's vehicle. I don't see how Mr. Toro could say that he never saw the plaintiff's vehicle under these particular circumstances.
Thank you.
Thank you.
U.S. Pony Holdings versus Fashion Footwear.
May it please the court, Kevin Fritz from Meister, Seelig & Fine on behalf of the appellant, U.S. Pony Holdings. We cited...
Sir, would you agree, in terms of the central finding by the court below that you disagree with, that there was no sale by the plaintiff or an affiliate of the plaintiff of more than 50% of its shares?
Yes, and Section 23.3 doesn't require that the sale be by the plaintiff or an affiliate thereof. Plaintiff never owned any shares of Iconic's brand group. What Section 23.3 says is that if Iconic's brand group, which is a parent company, enters into an agreement that sells 50% or more of the outstanding shares.
What agreement did it enter into that sold more than 50% of the shares? That's
The merger agreement.
But it did not sell any shares. The language is unambiguous and it requires the selling of shares in an agreement. And where is there any agreement where U.S. Pony agrees to sell shares?
The contract doesn't say that Pony has to sell the
What's the
shares.
exact language of the agreement?
In the event that the licensor, which is the Pony, or any of its affiliates, including but not limited to Iconics Brand Group, Inc., enters into an agreement,
Enters into an agreement.
which Iconics Brand Group did, the merger agreement, that sells 50% or
Okay,
more.
what agreement did it enter into where the agreement was the sale? That, you have to read that, enters into an agreement that sells. What
It
agreement
doesn't
is
say that Iconics Brand Group has to be the
It
seller.
does say that.
It doesn't.
It says it enters into an agreement. What sale occurred in that agreement?
The
agreement that the public
public
would buy.
shareholders sold their shares of
That
Iconics
is
Brand
not an agreement that it entered into that effectuated a sale.
It is, and it did.
That's your argument, okay.
I just want to go back, because maybe I'm confused, right? So what we have here, submerger, they do a tender offer.
Right, a non-affiliate, a non-affiliate.
Okay.
I want to make
So-
sure that's clear.
Oh, that's, okay, so,
I think the motion.
excuse me,
court
I'm
was
still
confused.
speaking, I'm still speaking.
Sorry, Your Honor.
Let's slow down. All right, so there's a tender offer, and then that leads to agreements with members of the public, right? To sell the shares.
No, the tender, it's a two-step transaction, Your Honor. It's a tender offer by a non-affiliated company. It was an affiliate of Lancer, which is a private equity group. Then the second step is the merger transaction, where the two companies are merged. So I think the motion court was confused.
So
Oh,
counsel.
no, we're not confused at all.
Your Honor, I said the motion court.
Oh, okay.
So counsel, looking at, you're referencing section 23.3 of the fashion agreement, right?
Correct.
Okay, so you're also talking about a two-step agreement.
Right.
Reading this as it's written, this appears to be a one-step agreement. Would you agree? As my colleagues have been pointing out, the language says plaintiff or any of its affiliates enters into an agreement that sells. So if you take a look at the plain language of 23.3, explain to me how an agreement that sells 50% allows for a two-step as opposed to a one-step agreement.
We cited both federal and state common law and federal and state statutes construing the word sells in a broad fashion, and we also cited
No, I'm
cases.
talking about the plain language of the statute, which is
Okay.
how contracts are normally constructed.
It doesn't say Iconics Brand Group enters in agreement whereby it sells. It says that sells. And it was impossible for Iconics Brand Group to
There is no
sell.
agreement that sells. Why don't you, with the time you have left, there's still two major issues with this, which is the estoppel and how to calculate damages.
That's right, Your Honor.
Why don't you address the estoppel, so maybe you'll also have to address
Or for the estoppel, we think it's very simple. 11 months passed. The licensee repeatedly acknowledged that the agreement had been terminated.
Right, but that's not enough to show estoppel.
We have a statement by them that the agreement's been terminated.
That's also not enough to show estoppel.
We
Weren't
have.
they relying?
I'm sorry?
Weren't they relying on the letter they had received from your client to say that it had terminated?
Yes, and then 11 months later, when the sell-off period was about to expire, they said, oh, hey, we went and we looked at the SEC documents, and we don't agree that the termination right was triggered. Those are the same documents they could have looked at.
But did they have a duty to look at that?
I believe they did, especially after they acknowledged that the agreement had been terminated. They repeatedly did that in
Counsel,
emails.
you stated to them, though, your client stated to them that the agreement was terminated, that you had grounds to do it. And there's no other evidence in the record other than that they agreed because you represented to them. So when they did subsequently find out, why did they have any obligation to do it at any earlier time? Because they were relying on your representation that you had properly terminated the agreement and had the right to do it. So why did they have any duty of investigation beyond being able to rely on your representation and go forward based on that? And that's exactly what he testified that he did.
Because we told them that we were going to be entering into an agreement with a new licensee. We told them that right after
Right,
we
but they
terminated.
still were then relying on your client's statement that you had validly terminated the agreement. So why, since your client repeatedly represented that they had the right to terminate the agreement and therefore had the right to enter this new license agreement, what triggered their duty of investigation to go beyond that and not to otherwise just rely on your statement that you had properly terminated the agreement?
Again, we told them we were going to change course and enter into an agreement with a new licensee. We told them
Right, but
immediately
you
after.
told them that
Right.
based on the same representation that you had validly terminated the agreement.
Right.
And if you had validly terminated the agreement, they would have then had the right, not have any right to object to you entering into a new license agreement. So how does that support estoppel?
Judge, under the scenario you're proposing, they could have waited 10 years to then challenge the termination, even though we had, by that point, had signed up a new licensee. And by the way, I should mention, in another order,
But you still, if we ultimately find that you breached the agreement by the way that you handled this transaction, then they have a right to sue on that agreement until the statute of limitations. That's the final date. It's not 10 years because it's not a 10-year statute of limitations, but any time within the time you potentially breach the agreement, they have right to bring suit.
I want to make sure the panel is aware of the relief they're seeking in their counterclaims. They want a declaration that they are still the licensee and they can use the mark.
Okay, then let's go to the let's go to the damages issue. Because let's assume for purposes of the damage and that, I'll let you do a rebuttal. I'm going to give you the rebuttal time to talk about this issue of the profits. Oh, go ahead.
Good afternoon, Your Honors. Aaron Solomon from Oved & Oved, LLP, on behalf of Respondent Fashion Footwear on most of the appeal, and we have a one cross appeal on the issue of the estoppel. Very briefly.
Why don't you start with the profits, since that is
I'm
clearly...
gonna start with the-
Why don't you start with the profits issue? There's
The lost profits, the damages issue.
right, the law of damages, what damages should apply?
Okay, so we'll go in reverse. This contract in particular does not have a limitation clause or any clause that says you can't look at the headings when interpreting the contract. Therefore, the law is you do look at the headings when interpreting the contract. And where do we look in this case? Paragraph 18 or section 18 says rights upon termination.
So is your argument that under paragraph 18 and paragraph 22.3, you get direct out-of-pocket monetary damages? Is that the argument you're making?
That's exactly it, because it's exactly what the contract says. In 18.7, it says you don't get damages except when you're improperly terminated, you get your direct out-of-pocket damages, which is exactly the situation we have here. We were improperly terminated, we get our
Has
direct out-of-pocket.
anyone laid out what those direct out-of-pocket monetary damages are? What does constitute or doesn't constitute direct out-of-pocket monetary damages?
Yes, Your Honor, and whether when we lay that out to the court at a trial or in a subsequent motion, whether it falls under a direct out-of-pocket or not is an issue for the court to decide then. But here what
And
happened...
What's your best argument as to why Section 16 of the agreement doesn't create a disputed issue of fact as to the profits issue?
Okay,
It definitely does say something different than the paragraph you're relying on.
It does say something different, but so does my children's lunch calendar. If I want to know what they're serving Wednesday, I go to Wednesday, not Tuesday. Section 16 is about insurance and indemnity, and it very clearly says in the first part, Fashion has to indemnify Pony. Then it says Pony has to indemnify Fashion, and then in 16...
And I agree with you that it does talk about insurance and subrogation, but when you look at the language of 16.7, it does say that plaintiff's liability shall be limited to the amount of any sales royalties received by plaintiff from defendant under this agreement. So why shouldn't that language, which does seem a little broader, even though it's under the subrogation provision, not create an issue of fact as to what the scope of damages would be if you are successful in one?
Sure, two reasons. One, both parties agree the contract's unambiguous, so it's very clear.
I'm sorry, both parties what?
Agree, the contract is unambiguous, it's clear. And when you look at this section, which only concerns indemnity, if you read 16.5, 16.6, and 16.7 in order, here's how it reads. Pony will indemnify Fashion, but only a little bit. In 16.5, it says they won't indemnify us for special damages or consequential damages. 16.6 says they won't indemnify us for lost profits. And then 60.7 says, without prejudice to the exclusions and limitations of liability above, and mind you, paragraph 18 is after this, in no event shall licensor, that's Pony's liability, arising out or in connection with this agreement, or any breach, non-performance or termination, no matter how fundamental, including under indemnity, and I'll hit that in a second, exceed the amount we paid them for the past
You're
12
saying it
months.
applies to the prior paragraphs, which clearly refer to, okay, let's go to the middle argument, which is the estoppel argument.
Great.
Why didn't the court below correctly find that there is an issue of fact as to estoppel in this case, assuming that we agree with the trial court about the interpretation of the contract?
Okay, so a couple reasons. Let's start with one. What they're essentially saying is we waited too long to sue them, even though we're within the statute of limitations. So it's really a laches defense, which wasn't pled as an answer.
I don't think
and
it's
waited.
a latch. Estoppel is different than latches.
It is.
The court analyzed it under estoppel, not latches. So let's stick to why there is an issue of fact as to whether estoppel should apply.
There isn't. And let me just, before we get
Which
into
does stop the statute of limitations.
right, the elements that they don't hit, I'm going to hit that in 1 second. But before I hit the elements that they don't hit and they can't hit, I first want to discuss two causes of action we have. One is for declaratory judgment, put us back into the contract. You terminated us, put us back in. I want to go home.
But you already agreed you're limited to out-of-pocket losses. If you agreed that we have to interpret the contract to limit you to out-of-pocket losses does not include the remedy of being put back into the contract. So even under your interpretation of the damages provision, you never get put back into the
I
contract.
understand that. My point, why I'm highlighting is, if their claim is, if Pony's claim is, well, because you didn't complain soon enough, we replaced you, which is why they terminated us in the first place, to replace us. But if they're saying you didn't complain and sue us right away, so we replaced you, well, that might defeat my ability to get back in, but I have 6 years to sue you for damages.
But what about the argument that they never, if you had earlier stated that they breached their agreement and you could have easily known that and found that out, then they never would have entered into the subsequent agreement with someone else to distribute the Pony brand. They would have stuck with you to avoid having to pay these damages.
Okay, number one, they terminated us. So they wanted to replace us in the first place. So the notion of,
Right, but if you had immediately said to them, hey,
Can't do
this
that.
termination is invalid, you can't do that, they might have decided, hey, we don't want to get into this fight and we're not going to enter another agreement, we're going to stick with the contract.
I have no
That's their argument.
I have no obligation to do that, and my mere silence can never be the grounds for an estoppel claim. I have to affirmatively misrepresent to them. We have case law, and it's in our brief, that mere silence doesn't give rise to an estoppel defense, and that's what this court's held repeatedly. And on top of that, even more fatal to their claim, is that this court and the Court of Appeals have held that when it's your conduct that causes me to do something, so they terminate, we don't complain fast enough for them or recognize.
Sometimes silence can create an estoppel in certain circumstances. It's not a blanket.
But when they're the ones who start the ball rolling, it's their termination that caused the problem. Us not figuring out that it was fabricated or improper early enough, the Court of Appeals has held in Triple Cities, and this court has held in Serendanis and in Goodfarb and in Mercandante that when you are the one who starts the action, if I rely on you, you then can't rely on me relying on you, which is what your honors were saying to opposing counsel at the beginning is, it's their termination that caused us to say, I guess you're saying we're terminated, let's figure out what to do next. If a landlord says to a tenant, your apartment's now market rent, if you can't pay me $30,000 a month, you got to get out, and the tenant goes, okay, I guess it's market rent now, I can't afford that, I leave. The tenant still has 6 years for breach of contract claims, even though it figures out later that wasn't true, but it's the landlord who started the mess. Pony's the one who started this by saying it.
The landlord can't argue that the tenant's equitably.
Right, because the tenant didn't wake up early enough and hire a lawyer and sue me that the landlord somehow is hurt. And on top of all this, we have to reap a benefit. We had 4 years to sell $3.9 million worth of goods. They're sitting in a warehouse we're paying for every month. What was the benefit we got? They let us sell for a couple weeks in Turkey, and we couldn't sell any shoes. We didn't want to sell in Turkey. We wanted 4 years to sell in America. What was the second benefit we got from this fantastic delay? We got a company that that we're affiliated with but isn't owned by us, got relief from a license from one of their unrelated entities. So essentially, because someone else's brother gave my mom a favor means that I got a benefit.
Thank you. You'll have a minute in rebuttal also.
Thank you, Judge.
Why don't you start with the profits issue?
Yeah, Your Honor, I think you hit the nail on the head. The
Let
plain
me ask you,
language.
because 16 does, when you look at it, seem pretty clear that it is talking about insurance and subrogation, and all the provisions leading up to 16, I think, .7 clearly are referring to situations where third parties trying to assert liability as against the plaintiff or defendant. It's not talking about a situation where there's a dispute between the two parties, and then as opposed to 18, which clearly talks about improper termination. So why shouldn't the more specific language of 18 trump the much more general language of 16, which does not at all clearly apply to a wrongful termination situation?
Because there is broad language in 16.6 and 16.7. It says, it refers to the breach, non-performance, or termination of this agreement, no matter how fundamental, including under any indemnity. So what opposing counsel is asking you to do is just ignore the phrase including, even though later in the agreement it says that including, it means including but not limited to.
Thank you.
Judge, if I may just briefly touch on that one sentence, which is the parentheses that say including under any indemnity. What that means is if Pony has to indemnify Fashion for a breach, they're limited to 12 months of what we paid them, including if that breach is not indemnifying us. That's what that including indemnity means. So no matter what, whether they didn't have the license in the first place and we have to terminate the agreement, whether they approved designs that turns out to be someone else's designs and it's a copyright violation, and if they have to indemnify us and they don't, no matter what happens, their damages in an indemnity provision, an indemnity situation, is 12 months of what we paid them. Because they don't want to come out of pocket for what, other than what the benefit they've gotten under the bargain. That has nothing to do with Section 18 and 22.3, both of which discuss what happens if there's a termination and what the remedies are if there's a termination. And here we were improperly terminated under 23.3, and I'm not going to get into it because Your Honor seemed to have it. And we have almost $4 million sitting in inventory that we can't sell.
Thank you.
Thank you, Judge.
People versus Samson?
Good afternoon, Your Honors. Catherine Pecor with the Legal Aid Society on behalf of Sammy Samson. Can you hear me okay?
Yes.
So this case is full of constitutional errors that require reversal, but I'd like to begin with the patent violation, and then if there's time, I may get to the warrant issue and the carpenter issue.
Well, let's assume that there was a patent violation in accessing Mr. Sampson's Brooklyn apartment with his mother, et cetera. Would you not agree that by the time they actually questioned him about 9.5 hours later after the arrest, where he was properly Mirandized, that whole discussion, as well as dealing with his cell phone then and eventually getting a warrant for it, that the attenuation clearly, I said assuming there was a patent violation, would overcome that whole concern that you're raising now?
So I think the most important fact to consider here is the flagrancy and purpose of the police conduct, which is what we emphasize in our briefs. And the entire point of going to Mr. Sampson's home and doing this without a warrant was to be able to circumvent his indelible right to counsel so that they could question him before he had the...
Could you deal with the attenuation question first?
Oh, I was speaking of this as an attenuation factor in the sense that the confession, by the time they questioned him, the confession was exactly what they intended to get from the outset. That is why they went in without a warrant, because if he had had counsel, they wouldn't have been able to do that. There's a direct causal connection between the illegality and the confession. And yes, there is a time delay there. I think we don't have any evidence of intervening factors that would have severed that causal connection. which is really critical, especially given the sheer lack of evidence of what happened with him while he was in detention at the precinct and also during the interrogation itself. We don't know if he was ever offered food or water or access to the restroom while he was sitting there in that cell. And he's in continuous custody. Nothing's really happening to him during that time that would eliminate the taint of the illegality. The confession needs to be, an act of free will. And I think given the very bizarre circumstances surrounding the waiver and the confession, I don't think we can say that Miranda, inoculated the police conduct. I mean, before he even waived his rights, he's confronted with a waiver form with the wrong person's name on it, the name of an informant. He's told by Detective Habib that, oh, I've already spoken to your co-defendant, I know everything about the case, implying, you have no real choice but to speak up. I think when you look at all these strange circumstances and then the lack of evidence of what happened to Mr. Samson while he was in custody, I don't think we can really say that the time delay alone established attenuation, again, especially in light of this conduct being so egregious. And as for the phone...
The cell phone a second. So to the extent that the defendant was in the police car using his cell phone on the way to the precinct, was there any attenuation there? Is there any factor that we should consider?
I don't believe so. And the main issue here is that we don't exactly know when or where or by whom the phone was taken. It's very bizarre because McBride, the detective who arrested him, didn't seem to know when it was.
He was texting from the police car, wasn't he?
Sorry?
He was
Yes.
texting from the police car.
Right, so that does seem to suggest that at most there was a 30-minute to an hour delay between the arrest and when the phone was recovered. I don't think that by itself establishes attenuation. I mean, there are federal...
Could you first address, which we haven't talked about, whether there really was a patent violation in the first place?
Sure.
Since it seems pretty undisputed that he wasn't arrested inside the house, that he voluntarily left the house.
I think this
There's
is...
an argument that that's supported by the record.
So the Court of Appeals in Garvin, a 2017 case, said that it doesn't matter where exactly the formal arrest takes place, because the issue with Payton and the Fourth Amendment is that physical police intrusion into the home.
Right, but it has to be an intrusion. If they didn't intrude, but they went in a reasonable way and he voluntarily agreed to leave the house, that would not rise to that level. So what about this case brought it to a violation?
Sure, so I think the best place to start is with the initial intrusion when his mother answers the door. So the record shows that this happened at 6 a.m., she's half asleep. She hears this aggressive ringing of the doorbell. She doesn't know who's there at the time, but she clearly realizes...
Didn't she voluntarily allow them into the apartment and voluntarily bring them into the bedroom?
So the only evidence as to that initial intrusion, I guess, is that she opened the door partway and stood behind it because she was not dressed and she wanted to, maintain some privacy. But
Counsel, was there a doorbell, or did the two officers knock on the door, which was promptly opened?
There's a dispute about that, and I think that...
Was there a doorbell, or was it knocking?
Yes, there was a doorbell. So Ms. Samson testified it was a doorbell. Detective McBride testified that he was knocking. And I do think that's a problem because the court should have resolved that discrepancy. It's certainly a relevant fact. But at the end of the day, it's not dispositive of the Payton issue because the court did credit Ms. Samson's testimony. And, she described all the circumstances that led up to her opening the door. And the only real evidence sort of indicative of consent is McBride's testimony that she was extremely nice and allowed us in. And I don't know what allow means. That could mean any number of things. That could mean...
Didn't she ask them to leave after defendant left?
So I don't think that it's that clear. I think she said that she asked them to leave numerous times, and she did explain that the detective, I know there was one detective who made an arrogant comment after Mr. Samson has left. But I really don't think that's the crux of the issue. I mean, I think the issue is that she didn't do or say anything to suggest that they could come in. I mean, she didn't open the door wider. You know,
Well,
she did.
that was because she claimed she was wearing a flimsy nightgown, so she was sort of a little embarrassed. It was early in the morning, but that doesn't mean she was trying to be resisting.
You have more time on rebuttal.
Okay, thank you.
May it please the court, Andrew Seawald for the people. Good afternoon, Your Honors. I want to begin just by first noting the overwhelming proof in this case, even without any of the contested evidence. There was no doubt that the robbery occurred, that it was a gunpoint robbery. The sole issue in the case was whether the defendant was the perpetrator of that robbery. The defendant matched the robber in terms of build and skin tone, and in the 2 days before the robbery, the defendant texted with Raphael Jefferson that he was trying to get a gun, that he did get a gun. He sent a photo to Jefferson, the co-perpetrator, the off-site perpetrator of the robbery. He sent Jefferson a photo of the gun, and then they texted about Jefferson picking the defendant up at his Brooklyn apartment. So all of that happened leading up to the robbery. And then when 4 days after the robbery, when the police executed a search warrant at the defendant's apartment, they recovered the gun that matched the gun depicted in the surveillance video. They also recovered pants and sneakers that matched the pants and sneakers worn by the robber. And Jefferson texted the defendant after the robbery that it was time to pop champagne. So all of that evidence is not even contested by the defense. So I just want to note all of that.
Whether there was a patent violation or not?
Sure, absolutely. So the court below found that there was not a patent violation, and the record fully supports the court's determination.
And that's because the court had the hearing, listened to the witness's testimony, and made credibility findings.
That's correct. The court had Sergeant McBride's testimony, observed Sergeant McBride, and also observed the defendant's mother. And they both testified basically consistently about the police entry into the apartment. And some of the factors that the court noted in finding that there was no patent violation, that there was consensual entry, was that it included that the defendant's mother was not in custody, she was not detained, the police officers did not have their guns drawn, and I would point the court especially to this court's decision in People versus Hill in 2017, where the issue was whether the defendant's uncle consented to the police entry in that case. And the defendant in this case has discussed the time that the police arrived, 6:30 in the morning, has discussed the supposedly overwhelming show of a number of police officers. But I would note that Sergeant McBride testified that it was he and Detective Diaz, just the two of them, who went to the apartment.
And counsel, and when the police said that they wanted to speak with the defendant who was sleeping, it was the mother who led them to the bedroom.
That's correct. That's correct, Your Honor. But I would also note that under the defendant's mother's version, there were 4 police officers who came. And in People versus Hill, in that case, the question was whether the defendant's uncle consented to the officer's entry. And this court noted that there were, in that case, it was 1:30 in the morning that the police went to the residence in question, that they banged on the gate outside the residence until the uncle came, and then and that it was 4 officers in that case who went to that residence.
And while these 2 officers were present, the mother never said, I want you to leave, and certainly there was no testimony that these two officers ever threatened her in any way.
That's correct, Your Honor. So, even though there was evidence that she later on wanted the police officer who remained as they were trying to secure the apartment
For the search
for
warrant.
the search warrant, she didn't tell these police officers and that they needed to leave, and the judge at the suppression hearing, in fact, clarified that very fact that her requests for the officers to leave did not occur until after the defendant had already left with the police officers.
Counsel, this was an armed robbery, right?
That's correct.
And the officers went in with their guns holstered?
They went in with their guns holstered, yes. Yeah, there was, yes. Thank you.
I just want to be clear about one thing. We are not asking this court to disturb credibility determinations made by the lower court. You don't have to do that. This is a pure question of law, and we are arguing that the testimony was insufficient as a matter of law to establish anything beyond mere compliance. And we know under the federal and state case law, I mean, the Supreme Court has said, mere compliance is simply not enough. And to go back to the initial entry, because this is really important, there's a lot of facts in the mix that the ADA is referring to that happened after they are already inside the apartment. They didn't say, hey, we need to speak with your son. Could you go wake him up? That all undisputedly happened after they had already stepped inside the apartment. At the point of entry, all that happens is she answers the door. It's open halfway. She's standing there behind the door. The police say, hey, it's the police. The one version of events, they say, can we come in? But either way, then they just step inside. That is it. And once they are illegally inside.
Argument that that's insufficient. Thank you. Groutton versus 553 Marcy Avenue owners.
May it please the court, John Shore for plaintiff appellant. In a nutshell, Your Honors, this is a textbook labor law section 240 sub 1 case where the record is uncontroverted that my client was caused to fall.
Distinguish Aspromonte.
Absolutely, Your Honor. In fact,
Seems very similar to this case.
yes, and I also annexed or cited to the Brown case, but I will deal with Aspromonte.
The difference between the Aspromonte case and the Brown case, in the Brown case, the court said the affidavits were conclusory, and in Aspromonte, the court said the affidavits weren't conclusory. So that really seems what it boils down to, because both of these cases are like this case. So the only question then is how conclusory are the affidavits?
I cited
affidavits-
to the lower court opinion in Aspromonte, which gives us a little more information, and there are several key distinctions between Aspromonte and this case. First of all, in Aspromonte, the witness who they relied on testified he actually did not see the plaintiff fall, and that was part of the lower court's conclusion in Aspromonte
Right, but
in
that
rendering
wasn't
its
the basis- that wasn't the basis for our conclusion. We didn't rely on that factor at all in reaching our decision at the appellate division level, which is obviously what we're going to look at as the binding precedent.
Right, but
That wasn't even mentioned in that decision as a factor to be considered.
but also in Aspromonte, because if you look at the appellate record or references from the lower court decision, the plaintiff told the person, the safety manager, that there was nothing wrong with him at all. He felt totally fine. He refused to sign an accident report. In fact, in Aspromonte, he climbed up after the purported accident, a
Putting aside-
20-foot ladder.
Putting aside for a second distinguishing the facts of Aspromonte from the facts of this case, just looking at the law as enunciated by the First Department in the appellate decision, which obviously it's not a long, detailed decision, but looking at the law in that decision, how would that law properly be applied, and Brown, in this case?
In this case,
As we stated it in the appellate division decision.
right, in this case, again, unlike in Aspromonte, you had a witness who corroborated it, and their own so-called expert, the biomechanical expert, is purely speculative and conclusory. First of all, he did not even refer to or review Mr. Jackson's transcript, and conveniently in the affidavit, he does not even...
That didn't happen here, counsel. So here we have a very different situation with respect to what you're focusing on. Here we have a doctor, defendant's doctor, who says, under the circumstances here where the person reports having fallen 20 feet down, if he had fallen on his head, the survival rate is pretty close to 0. If he had fallen on his feet, you would be expected to find foot and ankle fractures and other objectively demonstrated traumatic injuries from deceleration. And here we don't have that. And the doctor who, the other doctor,
Bowles?
She's with Sarin, I can remember the first name, not the last name, Rosner, did a very, very detailed examination of the medical records, which were notable for their omission of injuries to the lower body. So how is it that you fall 20 feet and you're complaining of headache and upper body problems or conditions, and you have an abrasion, as to your exterior presentation, but you don't have anything else? Don't we have a question of fact as to what really happened here?
That, respectfully, Your Honor, goes to the issue of causation, because even Dr. Rosner at the end said, well, it's unlikely, but she didn't even rule out, Dr. Rosner, that there was a cervical sprain and a head injury, a mild concussion. Oh, then she said, well, that's just based on subjective.
Said there may have been a mild concussion.
Right, but that goes to causation.
I'm going to let you finish up and reply, but causation is part of the prima facie case. But I'm going to let, it's part of the case, but I'm going to let you respond to that about where does proximate causation fit in on a 240 case. Go ahead.
Good afternoon, Your Honors. May it please the court, Joel Simon from Smith Major for the respondents. I'm going to briefly mention, we were talking about the Brown case. Additionally, what Brown referenced is that there was no evidence that showed, that contradicted that the accident actually occurred. That's different from this situation, in addition to the expert issue. We are not taking the position that plaintiffs' allegations should be ignored. What we're saying is that nor that a criminal act alone, even one of this nature, eliminates the probative value of the allegations.
Ruled against your position on the criminal act issue, that's a basis for denying summary judgment. I think we've already held that in other cases. So why don't you focus on the issue of your two experts and the issue of whether or not there's really an issue as to whether the accident occurred or not.
Your Honor, there's discrepancies throughout the record. We got from the plaintiff's testimony, the witness's testimony. You have Dr. Bowles, you have Dr. Rosner, who both clearly set forth in their affirmations and statements that the incident could not have occurred as it did. Dr. Bowles says with a reasonable degree of certainty that there's no way this would have happened. You don't fall 20 feet.
I'm sorry, I didn't mean to cut you off. Your position isn't that this case should be dismissed. Your position is that you have,
Exactly, Your Honor.
You're opposed and you feel there's an issue of factor to liability and damages.
We're not requesting summary judgment, Your Honor.
I understand that.
We're simply requesting that when you look at all these things together, not separately, one by itself probably doesn't go where we're going.
What if
But
plaintiff,
all together.
what if plaintiff just didn't know how far he fell? What if
In
he
and
fell
of
through the hole?
itself, Your Honor, if that was the only issue, I lose. But that's not the only issue. We have a multitude, and the record is explicit with them, of discrepancies, different versions, the expert testimony. Mr. Jackson says he went on the subway with the plaintiff all the way back to his home. The plaintiff says, no, I was by myself. No one was with me the entire time, and I never got home. I went to the hospital. There's something not quite right here. And the judge did not rule on the actual credibility. The judge simply said there are issues. Let a jury decide whether they believe it or not. Thank you, Your Honor.
That's respectfully not a basis to deny summary judgment to say, well, he had a criminal record in the past.
Counsel, we already said,
Right.
I already indicated the first department was already held that the criminal record's not going to cut it. So I'd ask you to focus on the same thing I asked him to focus on, is why on this case is an issue of fact. And you started making an argument about proximate causation, but proximate causation is part, if they raise an issue of fact as to proximate causation, then that goes to liability. That doesn't go to damages.
Well,
So you refer to it as a proximate causation issue, and even if we accept that argument, then you don't win on summary judgment.
in this case, Your Honor, there's nothing different than any other case where they have their IME doctor or their defense doctor who 75% of the time in their reports say the injuries are not causally related to the
Yeah,
accident.
but they
He could
don't
not
say,
have had
they're
the
not like this
accident.
case. This case goes way further than that. They're saying there's no way that this accident could have happened in the way that plaintiff describes, in a way that sounds like it makes some sense. They're saying if plaintiff had really fallen 20 feet, or let's say the plaintiff got it wrong and really fell 15 feet or 12 feet, there's no way the plaintiff would have walked away with the injuries that plaintiff had. So that's not something you see in, I've never seen anything like this in these cases, other than Aspromonte, to be honest. This is not a typical argument that's made.
Well,
It's uncommon.
in Brown, the plaintiff fell 20 feet and they
The
disputed.
only cases that we have here, Aspromonte and Brown, so it's obviously not an argument that counsels are making all the time, that the court is, it's an unusual circumstance.
Right. They're relying on these two experts, one, this Texas biomechanical expert, who didn't even refer to, it was
So
selective.
you're out
his
of time, but you're saying the experts are not enough.
The experts are not enough. He
Okay.
didn't even address the cervical injury in his conclusion.
Thank you.
Thank you.
Arajen LLC versus Tapjet Holdings. Lots of parties in this case. Go ahead.
Good afternoon, Your Honor. Stuart J. Moskovitz on behalf of the appellants. Obviously, the principal issue here is whether or not there's an applicable forum selection clause. And it's our
So just so I'm clear, because there's some confusion, but the only issue here is forum selection clause jurisdiction. There's no arguments being made as to CPLR 301 or 302 jurisdiction.
Actually, there is. We also made that argument. I believe that if we win on the forum selection clause argument, we win everything. But we have also made arguments on 302. There's simply no connection, no nexus to New York.
So you made arguments, you didn't make an argument for jurisdiction, you made an argument against, but it's
Exactly.
that they made an argument. Their only argument is forum selection.
Exactly.
Which is all that really matters, what their arguments are, since they're the ones asserting.
And I agree. If there's no forum selection
Okay, so why do they lose on forum selection?
why did we lose on forum selection clause? Oh, why should they? They should lose because there's no
The
forum.
question is whether or not there is jurisdiction, so why isn't there jurisdiction on the forum selection clause?
The counts, and I laid this out in the brief, there are 8 counts here. There is no count whatsoever regarding either of the 2 documents that had a forum selection clause.
Which documents have a New York forum selection clause?
The loan agreement and the release.
Is there any, well, what about the,
The document that counts is the purchase and sale agreement, which,
no, but you said the loan document, but what about the
release that they call a letter agreement.
letter agreement?
That's the September 25th, 2023 letter that followed the loan document
Right.
in the
It's-
record.
It's simply a release. It's not an agreement. It wasn't signed by anybody except.
So the question we have to look at is there an agreement that has a New York forum selection clause that involves these parties to the litigation that has a cause of action asserted under it?
And the answer is no.
What about the letter agreement and the fourth cause of action for fraud is against Kesselman? Why doesn't that fit under it?
The letter agreement, like I said, is not a letter agreement. They keep calling it that. It's simply a release. There's no agreement there. He released, and by the way, in that release, he did not release the claims that are pending in Florida that they're trying to get.
But again, we're not litigating the merits of the case.
Right.
We're only talking about jurisdiction. So you might later argue that agreement, release, whatever, did not impose any substantive obligations, and so as a matter of fact, you can't go forward and state it, but we're not getting into that here, because we're just getting into personal jurisdiction here. So under just getting into personal jurisdiction analysis, why, at least as respect to Kesselman, and at least with respect to the fraud claim having to do with the $1 million paid, why wouldn't there be personal jurisdiction with respect to that claim?
There is no forum selection clause in any document that there is a claim against the defendant.
Well, let's focus in on the fourth cause of action for fraud against Kesselman.
Right.
Which, again, you might later argue that doesn't impose any obligations, but there are reps in that, or statements in that agreement about that they're saying they relied on and states the cause of action for fraud, so why wouldn't that fall under it?
The agreement that the causes of action rely on is the purchase and sale agreement, the MIPSA.
Forget about because that doesn't have a New York form.
Exactly.
So that's not answering my question.
I'm sorry.
I'm asking you a specific question
Right.
about their claim having to, and she's going to address everything else, but I'm asking you now about the claim under the fourth cause of action for misrepresentation against Kesselman. Why doesn't that arise on its face under the letter agreement? What's wrong with that argument?
Okay. Obviously, if we're dealing with a tort, and that is, the misrepresentation to Kesselman is about a tort, and that obviously does not apply to a forum selection clause because it's a tort. It has nothing, the only agreement it could.
Well, it's saying there's a misrepresentation in the agreement, and the form selection clause covers any dispute related to the agreement.
Right. Except there's no misrepresentation with respect to any agreement other than the purchase and sale agreement, which has no forum selection clause. Okay? There is no cause of action, no allegations, nothing whatsoever with respect to the release that they're trying to call an agreement. None. The only way an action could be raised is if he violated the release, which he did not.
Okay, so putting that aside, because I understand that's your position, what about the argument made by counsel that all of these agreements are interrelated, they're all meant to be read together, they all arise out of the overall transaction having to do with the purchase of these two airplanes, and that they should all be read together, and under that standard, we should find that there is personal jurisdiction of other defendants.
Because you can't piggyback on something where there's no back, and there's no back. All right, the MIPSA is the only agreement that's applicable here. It specifically says all prior agreements, all representations, warranties, promises, they're all gone. This is all that counts, and there's no forum selection clause. And that's what this case is about, that. His representations all relate to that, and they're waived anyway by the MIPSA. So
Thank you. Thank you very much.
Good afternoon, Your Honors. May it please the Court, Amanda Freire for plaintiffs' respondents. And I'd like to just address
Let me ask you the same question directed towards you. It appears that what other than the letter agreement creates a basis for jurisdiction in New York under the forum selection clause?
So obviously we have the letter agreement. The MIPSA applies New York law, and it does provide.
But it
doesn't have a forum clause, but
it now it doesn't have the.
I
law
agree
was
that
incorrect,
concede
right?
that it does not have a forum clause.
Okay, so it doesn't have a forum selection clause.
Well, the loan note. Okay, so the loan note.
What cause? First of all, who?
Oh, I'm sorry. What cause of action?
as to the loan note.
Yeah.
First of all, to fit under the form selection, 3 things have to be met. There has to be a course of action. It has to be that one of these defendants is actually a party to it that you're asserting a claim against, and the claim relates to that agreement. So other than, and I'm going to ask you later about the letter agreement and the 4th course of action, but other than that, what claims do you have that fit all 3 of those categories?
So the loan note was entered into by Starship and Arajen and the principal of Arajen.
But does a loan note have a New York form selection clause?
Yes, mandatory form selection clause.
Okay, so what
Yes, it does.
causes of action under this complaint arise out of the loan note?
Count 4 is fraudulent misrepresentation under the loan note, letter agreement, and the
Against
LSAs.
Kesselman?
Against
Count 4
Mr.
is only
Kesselman.
against Kesselman, right?
That's correct. Well, there is, putting aside the letter agreement for a moment, which was prepared contemporaneously with the loan agreements, there's a recognition in that letter agreement that Tapjets was acting as the payment agent for Starship. So the payments were actually made directly. Tapjets Incorporated.
Is the 4th cause of action for fraud asserted against any defendant other than Kesselman?
No, I don't believe that it is.
Okay, so putting that 4th cause of action aside, because I think that's your strongest argument, what other cause of action are you arguing fits under the form selection, and why?
Well, we asserted declaratory judgment actions under the management agreements.
Right,
Also,
but the management agreement doesn't have a New York form selection clause.
we also asserted declaratory judgment actions regarding the loan and servicing agreements.
That also doesn't have a New York form.
It has a permissive form selection clause.
What?
The loan, servicing, and aircraft agreements contain permissive form selection clauses. The parties,
It said they may.
They
That's
may.
the language, but there's no express language like in the letter agreement.
the loan note contains.
No. The FSA agreement does not
LSAs.
have the
Mandatory.
express language
Correct.
as in the letter agreement,
It
correct?
is not mandatory, it's
Right.
permissive. So
Doesn't
I
even
would,
break it down in terms of the separate provisions that are in the letter agreement where, because one provision says New York law applies and the other provisions provide for a New York forum. They're 2 separate
right,
provisions.
so the LSAs, in our interpretation of those agreements, there is a choice of law and a permissive forum clause. So there's an agreement that any claim may be brought in either state or federal courts in New York.
Right.
And I would say that's sufficient to assert a claim in New York. I believe that's a waiver. Although it's not mandatory, the parties have agreed that they may resolve their disputes in New York. And so we have asserted claims under the LSAs. The LSAs contain representations about the accuracy of the financial statements. The LSAs also recount the use of the funds and how they were used. So the other thing about the LSAs is that Arajen is a secured lender to Starship. And so there's a dispute as to, assuming that Tapjets has a claim against Starship for additional alleged liabilities, there's a dispute as to who would get priority as a creditor. Let's just assume that their arguments and their claims in the Florida case are valid, that they have liabilities. Well,
Is Tapjet holding a party to the loan note or the LSAs? So you're using that to argue your form selection clause, but is Tapjet holding a party to the LSAs?
I believe it's Tapjets Incorporated, that's
The
correct.
2 defendants in this case that you're trying to assert jurisdiction over, they're not actually parties to those LSAs. So if they're not parties to the LSAs, how can that be the basis for asserting
Well,
a form selection clause jurisdiction over them?
that's a fair point. So
That's why I
Tapjets
say, other than
Incorporated.
the letter agreement, it has to meet all those aspects.
Tapjets was the sole owner of Starship at the time of that these agreements were entered into. This is before the purchase of the agreements. Mr. Kesselman signed those agreements, he made representations, and he was acting, he ultimately...
Again, that goes to the 4th cause of action for misrepresentation. It doesn't go to whether your claims as to the LSA can go forward in the New York courts.
What about defendants' argument that the 3rd and 6th cause of action should be dismissed because the Florida action was started before this New York action?
It's our view that the Florida action was improperly filed. It should have been brought in New York. And the letter agreement specifically refers to amounts that Tapjets claims it was still owed. And as Mr. Moskovitz pointed out, the letter agreement specifically provides that Tapjets is reserving its right to assert additional claims against Starship for alleged owed liabilities. And so that is the subject matter, part of the subject matter of the letter agreement. The forum selection clause in the letter agreement states that any and all disputes relating to the letter agreement and its subject matter must be brought in New York State Court. And so it is our view that the management agreements to which were drafted years before our client entered the scene, there is no forum selection clause in those agreements, but they are then modified. There's an agreement that any claims would be brought in New York. And so it should not have been brought there to begin with.
I totally didn't understand your last sentence. How can there be a claim under the management agreement gets brought in New York?
Because the letter agreement
You're saying the letter agreement swallows everything else, basically.
I think there was
I
think there was an
That's your
understanding.
argument.
Well, certainly Tapjets was not a party to the LSAs or the loan agreements, but
You're saying the letter agreement brings them in on everything.
well, because they acknowledged that they were payment agent. They acknowledged the reps and warranties.
Thank you. You have a minute in rebuttal.
Very quickly, Your Honor.
What's your response to what you just said?
The fourth cause of action doesn't even involve the loan agreement. The loan agreement is involved in the sixth cause of action, but that's a request for a declaratory judgment asking the court, please ignore the Florida action and decide it here. The letter agreement, as I think everybody finally understands, is not an agreement at all. It's a release. It doesn't bring anything into anything. No cause of action was founded under the letter agreement. In fact, the release actually excludes the maintenance agreement that is the subject of not only the Florida action, but the last 3 counts of this complaint, 2 of which were added at the end.
Thank you.
Thank you.
No, she has a minute. Oh, you didn't take your minute, or did you want your minute, right?
Oh, I didn't think that I had a minute. I don't have a cross appeal.
Okay, thank you.
Thank you.
Rosario versus Montafure Medical Center.
Good day. Good day, Your Honors. For the plaintiff appellant, Raymond Schwartzberg, the decision and judgment below should be reversed. This 46-year-old mother of a few should not have lost her full chance of recovery and survival in the events of that day. As in almost all these cases, there was a battle of the experts.
Yeah, well, you had an expert who was a surgeon, but not necessarily an expert in emergency services, and he wasn't really, except for saying that she should have been administered oxygen, which is what he said in his opinion, or I don't know if it's a he, whatever the plaintiff's expert said, but she was administered oxygen, so he didn't get that right. Your expert didn't get that right, and that intravenous was indicated. I'm not sure why, and that he claimed that they didn't go fast enough. So how did your expert, with that opinion, counter the actual ambulance records and the emergency room records?
Yes.
Where all her vitals, both in the apartment, in the ambulance, and upon presentation in the emergency room, were all normal? No respiratory distress, no erratic vitals, if you understand what I'm saying.
Because when the emergency technicians entered the apartment, they were told that she is sickly. She had several conditions. One was asthma. She was saying she can't breathe. During the 15 minutes, and time was a wasting.
Counsel, why does any of that matter if the record evidence is that at the time she arrived at the hospital, her vital signs were normal? If they were normal when she arrived at the hospital, how could anything that have happened prior to that point been the proximate cause of her injuries?
Because she didn't get oxygen until she was exited from the apartment, which was at a different time than you were even
Then,
told.
counsel, how does your expert address their argument that her vital signs were normal when she arrived? How does your expert refute that? And that her
Because
breathing was normal
the
time she arrived at the hospital.
the oxygen should have been, was one of the approaches that
What
would
does
have
your
been needed.
expert say
Because-
about that? Does your expert say that if she had received oxygen, then it would have not showed up at the hospital and it would come up later? I mean, how does your expert address it?
Yes, she did not have a heart attack. She had cardiac arrest. And had she been brought to a facility at Montafure within the time that she should have been brought, in other words, not 45 minutes after the EMT walked into the apartment, they took 15 minutes in the apartment, 15 minutes downstairs, doing nothing for 15 minutes. They
Counsel, was
started to give
anybody-
oxygen.
Was anybody in the ambulance with the EMTs?
Pardon me?
Was anybody in the ambulance with the EMTs?
Two EMTs and nobody else.
Right, so how does anyone know that the EMTs were doing nothing within the ambulance after transporting her inside?
Because the husband, the mate, went outside to get his car and drive to the hospital. And he saw that at last, for the first time, she was being given oxygen. And that's all they were doing. All of the ACR reviewed by the surgeon expert who did heart surgery among his cardiopulmonary surgical expertise and extensive skill, knowledge, and experience.
How do
They
you
wasted 45 minutes doing nothing, including 15 minutes.
So, counsel, looking at the record, first of all, your expert, the surgeon, frames everything within the context of what a physician's assistant should do. Here we had EMTs, not PAs.
Absolutely.
Paramedics, excuse me.
The first rule, which was violated, was get the patient to the emergency care as fast as possible.
But that's different from what I'm addressing. What I'm saying is that there's different standards for PAs, for paramedics, as opposed to EMTs, because they have different skill sets. So, for example, the surgeon says that the EMT should have inserted a line, but EMTs aren't allowed to insert intravenous lines.
That is something that could have and would have or should have happened at an emergency room. It is correct that the EMT could only take certain tests and not do anything internal, but had the EMT done their job, not spent 15 minutes in the apartment scratching their head, what is happening here? Over 50 times, told, I can't breathe, she can't breathe.
My understanding from the record is the decedent's daughter actually testified that the decedent was administered oxygen in the apartment.
In the apartment.
She wasn't happy with it. She would have liked a mask versus a cannula, but she testified under oath that her mother got oxygen in the apartment.
No, what she did testify
It's in the
to was
record
when
on page 60910.
what she did say is that there was some exchange between the daughter and one of the two EMTs. They were trying to put a tube into the mother's mouth,
She didn't like
and
the
that
EMT.
wasn't working.
You'll have time for rebuttal. Thank you.
So the daughter put
Thank
the
you.
mask on.
You'll have time for rebuttal.
May it please the court, my name is Alan Friedberg, and I'm here on behalf of Montafure. I got to tell you that the expert that the plaintiff claims he says is an expert, a heart surgeon. I would not know that. I never got a copy of his CV. It was redacted underneath, and it's redacted in this record. You don't have a CV in the record unless you have something special that the plaintiff provided you and didn't provide us. The 1,268 pages of records does not contain a CV of this purported expert
But
who
even if we
reviewed the
had
case.
CV, isn't your main argument that he was not an expert as to EMT procedures and what an EMT should or should not do?
That's exactly right. He has no ability to decide or opine on EMTs, because EMTs are covered by REMSCO. As our EMT expert, Mr. McCloskey, explained, EMTs have protocols that they have to provide for and have to follow. So there's no question that this expert didn't have the expertise to be able to opine that. Certainly not in 2016 before either of the EMTs testified.
How does this expert address the finding that the vital signs were normal at the time of arrival and the breathing was normal at the time of arrival at the hospital?
How does the plaintiff's expert? Plaintiff's expert never addressed it. That's the point. He never addressed the proximate cause issue at all. He just concludes speculation
And what does
that
your
had the
expert
patient
say
gotten there.
What does your expert say about that? About
My expert says
the significance of plaintiff's vital signs being normal and breathing being normal at the time of arrival.
That it wouldn't matter if she got to the hospital 10 minutes sooner or 15 minutes sooner, assuming that they were dilly-dallying, which plaintiff claims they were, and I could lay out the 28 different aspects of their behavior that had to be conducted within the 32 minutes that they had when they came and they left.
Did they counter in any way your argument that none of that, your expert's argument that none of that would have made a difference, that because of the way she arrived at the hospital?
She arrived at 8:27, according to the Montafure record, and she at 8:39, 12 minutes later, had absolutely normal vital signs. Her blood gas was 99% on room air, which means Montafure didn't even give her oxygen, even though the EMTs were giving her oxygen because she had abdominal complaints from the time that they first met her, and was confirmed by Mr. Trochi, the common law husband, who looked in the window and saw that the EMT in the ambulance was giving oxygen and also taking notes, because he took her vital signs in the ambulance, Mr. Irati, and documented normal vital signs after they strapped her onto a gurney, and they put the gurney into the ambulance, and they tied the gurney down to make sure it wouldn't move. He took her vital signs, and she was getting oxygen. So the idea that somehow if that happened 10 minutes sooner would have made a difference is frankly preposterous. And here's my question: why wasn't an expert retained?
Let him ask the question.
I'm sorry, I'm saying, isn't that the protocol, that they had to take the vitals up in the apartment and repeat the vitals in the ambulance?
Exactly.
So they follow the exact protocol that the
Exactly.
plaintiff's expert had no comments on.
And his expert didn't even comment on it because he's just concluding that she was going downhill and they should have perceived it. Based on what? They took her vital signs in the apartment, in the ambulance, and then when she got to the emergency room, they took her there.
So, counsel,
there was no objective indication that she was deteriorating and was going to have a
Counsel,
sudden heart
to
attack.
the extent that the plaintiff, that the call indicated that the plaintiff complained of abdominal pain, nausea, vomiting, swelling, and bruising. She showed bruising. She said that she had fallen. Is there any indication that the immediate administration of oxygen, given these particular complaints, was the appropriate medical response?
The EMTs both testified that when somebody complains of abdominal complaints, that the protocol is to give oxygen, which is what they did. They gave her oxygen. And the fact of the matter is, when she was at Montafure for 12 minutes, they take her oxygen level by checking out her blood gas, and it's 99% on room air, meaning she's not even being given oxygen, and she has normal oxygen. So where's the respiratory distress? Judge Shulman, you and Mulrow made a determination with your colleagues that an expert has to base their opinion on the record, and they can't be contrary to what's in the records. And here, the plaintiff's expert in 2016 rendered an opinion that's contrary to the records and contrary to the testimony of the EMTs that testified subsequent to his writing this opinion without having a full ability to review the record.
Now, counsel, we know that the EMTs was at the scene for about 32 minutes, and the only thing that the plaintiff's expert addresses is this alleged 15 minutes of them doing nothing, and there's no evidence about that. But I want to know, was there any discussion about, how long it should take to check the vital signs, how long it should take to drive to the hospital, anything that was discussed?
Dr. Wiener addresses that, and Mr. Mikulski addresses that. The ambulance got there. They have to take their equipment out. They have to lock the ambulance. They have to walk up to the building. They have to go up the ramp. They have to buzz themselves in. They have to walk across the lobby. They have to go to the elevator. They have to get the elevator to come down. They have to go up to the elevator. They have to get off the floor. They have to walk down the hallway. They have to get to the apartment. They have to go in the apartment. They have to introduce themselves. They have to take a conversation to find out what the complaints are. They have to examine the
about
patient.
doing it in
take the
reverse,
vital
counsel?
signs.
In reverse, with the
In
plaintiff.
reverse,
What did
in
they say
reverse.
in regard to that?
They say that it was a reasonable time. That they both testified. They're both sworn after looking at the testimony of
No,
the
plaintiff.
EMTs.
The plaintiff, what the plaintiff said.
Plaintiff never addressed it. He just looked at an affidavit that the daughter wrote, who actually testified that they were in the ambulance for 20 minutes when she testified at her EBT. 20 minutes, meaning everything else took 12 minutes.
Thank you.
It's ridiculous.
Thank you, counsel.
The ambulance driver said this should have been a scoop and scoot or a scoop and run. Both phrases apply. This expert for the plaintiff was an eminent surgeon, and in the lower court, it was redacted because there was a previous motion to dismiss. So it was already on file, and it was all available to them. There was no secret about the expert's qualifications. He had the experience. He knew. He recited. He gave lectures about mortality of cardiac failure situations, cardiac.
Counsel, you would agree that there are specialties within medicine, and emergency medicine is a specialty unto itself that's different from surgery.
This expert had lectured regarding intensive care for cardiac patients. This person had.
Yeah, but the question isn't what happened once she got to the hospital. It's what happened before. Thank you.
Well,
thank you. Thank you. Rivers versus Panama Leasing.
May it please the court, Your Honors, John Shaw for the plaintiff appellant.
Welcome back.
Thank you, round two. Respectfully, the lower court got this one wrong. This was not
routine maintenance, correct?
Correct, Your Honor. This was not the mere change of a light bulb, and defendant selectively chose one section of the deposition, but when there was elaboration, which was uncontroverted actually, this clearly was not routine maintenance. My client, who is an electrician, had to use a drill. In fact, he testified that he had to shut off the electricity. He testified that after removing it, you had to use the drill to drill into, because you had cement to install these lights. Moreover, this is hardly something that is done by the ordinary person. He was given a scissor lift to do this work, and clearly the scissor lift was a failed safety device, and it's actually conceded by their own witness, who they annexed an affidavit, Mr. Ramachi, who said they were on an incline. The scissor lift was an improper safety device. The record is further uncontroverted that no safety harnesses were provided, no proper equipment was
How do
done.
you make sense of all these different cases, which have many different descriptions of what is or is not a repair versus not a repair?
Sure, Justice
There's a lot of different cases and a lot of different, what's your take that you want to argue to us on how to interpret all these cases?
Absolutely. When you're replacing a fixture, when you're doing something that does not merely involve getting up on a ladder and changing a light bulb, that is clearly not routine maintenance. In this case, this was a trained electrician, and it was not something that was done on a routine basis. They rely on two cases, basically, Smith and Picaro. Smith, the Court of Appeals held that it was routine maintenance. because the plaintiff or the worker was merely changing light bulbs. In Picaro, that was part of their job. The plaintiff testified that they would be doing this typically twice a week. Here, there was an inoperable set of lights, there was an invoice, and they were contracted to do this work.
You would agree that it's not in the context of construction, excavation, and demolition, correct?
I will.
So you don't have a problem with the
Absolutely.
dismissal of the 241 claim?
I will agree with Your Honor, even though in the job loan case, that was held to be an alteration. You could clearly say this was an alteration because you had to do this cement, but obviously for the purposes of 240 sub 1, you don't have to show, as Your Honors know, that it's in the context of demolition, excavation, or construction. Clearly, this was not routine maintenance. I'm not going to read the record. Pages 114 and 115 and pages 112, not to mention Mr. Ramachi's affidavit, establish that this was an alteration, a repair.
Counsel, was there any issue about the sloping, the ramp, the fact that a scissor lift had to be used because there was a slope, and the fact that there was ice, or the allegation that there was ice?
Even if the scissor lift had to be used, it was an improper device. Again, the burden isn't on the worker under the sanitist case to provide the proper equipment. Even again, the affidavit that they secured of Mr. Ramachi, who they rely on, said, hey, this was improper. We spoke to our boss and he said, keep working. And again, the burden isn't on the worker to provide a device that clearly, because it was slanted, it couldn't go up, and then they had to choose alternative methods. That's
Thank you.
violation. Thank you.
You may proceed.
May it please the court, Brian Ginsberg for Panama Leasing. As was discussed at the end of my friend's argument, this court has issued a lot of decisions in this area, and they need to be made sense of, particularly in the 240 sub 1 area. As far as those decisions go, there are 3 factors that we discuss in our brief that my friend on the other side didn't even respond to in his reply brief that indicate that summary judgment was properly granted on the 240 sub 1 issue. First is that this job did not entail major structural work. The only change to the infrastructure of the building occasioned by this job was drilling a couple small holes in the canopy to accommodate the screws.
Wasn't the wiring changed also?
I'm sorry, Your Honor?
Didn't the wiring get changed as well?
No, there's no testimony that the wiring got changed. The wiring was, as my friend on the other side accurately says, disconnected, and then it was reconnected again after the globe lights were replaced. But there's nothing like, for example, this court confronted, and Justice Schulman confronted as a trial judge in Caban, where there was splicing of wires together or diagnostic testing of various components. And certainly, again, quite different from that case, which my friend on the other side relies on, where there, after the worker was injured, completion of the job ultimately took 3 electricians working a total of 10 hours. Here, the job after plaintiff was injured was completed basically in the same afternoon.
So I'm looking at this, and didn't he have to detach the electrical wires from the old fixtures, rewire a new replacement light fixture, and drill holes into the canopy's concrete surface in order to screw new, smaller size fixtures into place, and then place a light bulb cover onto the replacement fixture?
I think that's approximately right, Your Honor.
Well, so wouldn't it be a repair?
Well, our view is it's not a repair for the 3 factors that I was getting into. Again, There's no structural or very little structural difference in the infrastructure versus before and after, just a couple of those screw holes. Otherwise, the profile of the relevant canopy section looks the same. And the job involved replacement of components that are expected to need replacements. It's true that it involved more than that, but this
But it's not maintenance, counsel. I mean, how could it possibly be maintenance if you are replacing fixtures using a tool in order to effectuate the replacement and then making holes into concrete?
Well, holes into concrete and the use of a tool have never been viewed, at least I haven't seen any case where they've been viewed as
Looking at the
talismanic.
totality of the circumstances.
That's right. And the totality of the circumstances, in our view, supports the notion that this was what the court has referred to as routine maintenance. If, however, the court is saying that, and my friend discussed this a little bit, about evidence or lack thereof of routine, actual evidence of how frequently this is done, I would point out that there's no evidence on the other side either. There's no evidence that this is not done routinely. So
Do you have invoices to show that this is done regularly at the building?
we don't have invoices, but we have two things I think that go in our favor for our prima facie case. And I do want to address why my friends on the other side don't meet their prima facie case, because they ask for summary judgment, of course, in their favor as well. The first is, at the center of all this, literally at the center, is the replacement of light bulbs. That is a component part that has a limited lifespan. But for the light fixtures themselves, Your Honor, although we don't have invoices doing this repeatedly, what our invoice does show is that the electric company that performed these replacements was not contracted for parts. In other words, the building had the light fixtures on hand, as far as the evidence in the record shows, which suggests that this is something that the building owners contemplate will need replacement from time to time. I would also say, though, that with the evidence that my friend on the other side relies on for the supposed non-routine nature of this, that Mr. Rivas testified that in the month that he had been working at the building, he had not been called upon to replace globe lights before. That does not establish a prima facie case in their favor of non-routine nature of this work, because it doesn't say anything about other employees. It doesn't say anything about what happened prior to that month. It's just not enough to show the burden that the plaintiff needs to show if he wants summary judgment in his favor on the 240
Sounds
sub 1
like
issue.
you would have had to meet your shifting burden of proof on that one.
I'm sorry, Your Honor?
Sounds like you would have had to meet your shifting burden of proof instead.
Well, our view is,
Plaintiff met its burden of going forward, you had to respond, right?
had that been true, I would agree with you. Our point, though, is that in terms of plaintiff asking for affirmative summary judgment in his favor on the 240 sub 1 issue, that he didn't even meet his prima facie case. So there's no need to look at the sufficiency.
So what if we disagree with you? What if we disagree with you? You know, my question is, what, if anything, did you, not you, but your client do to say, you know what, this is routine. You know, we do this ever so often where we have to disconnect the wires, drill the holes. Did you do anything like that? You know, your client.
There's no evidence either way directly attesting to the routine nature or not of this activity. I certainly agree with that. There's no testimony saying we do this every 2 weeks. There's also no testimony saying we never do this before, this is the first time, et cetera.
Thank you.
And I would just close by saying that I thought I heard my friend on the other side concede on the 241 sub 6 issue, that summary judgment was properly granted.
Thank you. Your time's up.
Happy to answer
We'll
any
address the
questions if there are.
241.6. If they win summary judgment on the 240, then we won't address the 241.6. Otherwise, we'll address it. We address it. So thank you. Oh, you have 2 minutes.
Yes. I will refer my friend to page 309 of the record of the owner, Mr. Bezos, who testified that they specifically contracted with the electrician because the the light fixtures were not operable, so they had to be replaced. That was page 309 in furtherance of your question, Justice Kern. This is clearly not routine maintenance. In the cases they rely on, it was changing of a light bulb, or in the Picaro case, it was something they were regularly doing. Here, the page 114 and 115 of the record, they had to use a drill to break into the cement to erect these fixtures. Clearly, this was not routine maintenance, and as the court noted, I clearly established a prima facie case, but they have put forth no proof to rebut that, to put in any evidence from anyone, including the owner, who actually conceded this was not routine by virtue of the fact that he said it was inoperable. And their own witness, who they got an affidavit from, again, supports my client's entitlement to summary judgment. He never disputed any of my client's testimony that hard hats were involved. He had to wear glasses because of the drilling, and they shut off the electricity, and there was testimony about the wiring of attachments. This clearly was not routine maintenance, and I think it was in the Caban case. In that case, I think, or it could have been that or another, I believe it was Caban. First, they thought they were just changing light bulbs, and then they said there's other problems, and that which involved more sophisticated work, and that was the basis for the courts of granting 240-1. Here, this was not a light bulb case. Thank you.
Agüero, Salatte versus Brealey School.
Judges, I'm an appellate respondent, so I don't know what side I should sit on. Is it okay if I just... Is there a cross?
Normally you sit there, I think, but it's okay.
Okay.
Normally everyone but the appellant sits on that side, but it doesn't really matter.
Good afternoon again. May it please the court, Patrick Lawless.
Welcome back.
Thank you. For the third-party defendant, appellant respondent, PAL. PAL's motion for summary judgment dismissing the contractual indemnification claim should have been granted. There's no evidence in this record that PAL, other than pure speculation, there's no evidence that PAL performed any asbestos abatement work on the staircase or caused this accident in any way. The logbooks...
I'm not finding it. Pal did perform the asbestos work. Oh, you're saying on the stairway?
On the stairs where the accident happened.
Let me ask you, this is one of the broadest indemnification clauses I've ever seen. There's really a great variety that comes, across the bench here. And this one's extremely broad. It covers just about everything. Since this is clear that he was using the stairway to go back and forth and do his work, how did it not arise out of his work?
Didn't... Well...
I mean, arising out of work is very, very broad, and he was only on that stairwell because he was working, carrying materials up and down. If it was a 241-6 claim, it would have been a passageway. He was working. So it arose out of his work.
But there's also, I believe there's also a negligence component of
There isn't a negligence component on it. Again, it's very broad. If you can point to any language, but I don't think there's any language in there that has a negligence trigger. It's simply arising out of.
Well, I believe that, but even so, PAL wasn't performing any work, so it didn't arise or wasn't caused by PAL's work.
The employee was working. What's your response to what I'm saying to you? You're saying it didn't arise out of PAL's work, but it was an employee of PAL who was injured on the steps, and he was injured on the steps while he was working. He wasn't on a break having a cigarette on the steps. He was carrying materials up and down. So how does that not arise out of PAL's work?
But there's also a question of fact whether it rose out of Howland Beerley's own negligence, which would preclude them.
Well, that would go to the issue of whether it's conditional or absolute, and we're going to address that when we address whether or not they're entitled to summary judgment on their 200 and negligence claims. If they get summary judgment on their 200 negligence claims, obviously they're going to argue for unconditional. If they don't, they'll argue for conditional. But for your purposes, the question is how could this not arise out of this very broad indemnification clause?
Well, again, I'll address that on my rebuttal then.
Okay.
Thank you.
Your Honor, if it pleases the court, my name is Gerard Benvenuto for a defendant, appellant, respondent, Howell and Brearley.
You have two issues to address.
Correct, Your Honors, and I don't know if the bench prefers what order I address them, since we addressed the...
Well, from one point of view, in terms of 200.
Yes.
You played no role there. You weren't even given access.
Correct.
PA controlled the entire work site.
Correct, Your
It's
Honor.
an asbestos abatement project with very strict protocols, safety protocols, correct?
That's correct, Your Honors.
So there's no way they could have been on actual or constructive notice of anything.
That's correct, Your Honor. And then arguing in addition to that, our position would also be that the defect itself was latent and not subject to inspection. And on that point, because it also touches on 240 foreseeability, and it also touches on proximate causation with respect to 241.6, I just want to note that with respect to plaintiffs' I think, seminal contention that underlies the opposition to all those causes of action is that you should have inspected, and implicit in that is if you inspected, you would have discovered this defective condition. And with respect to that, there's no proffer of any evidence whatsoever adduced by plaintiff that says, A, inspecting structural components, inspecting every step on an internal staircase is something that's done under the custom and practice of the construction industry. B, what
How
would...
does that go to the 240 claim as opposed to the 200 claim?
Well, that would go to 240 only because 240, for if we're dealing with the collapse of a permanent staircase, which is structurally integral to the building, meaning it pre-existed.
Let's do the first part of that, which is...
Sure.
Are you conceding or disputing that the stairwell was a safety device for purposes of the work?
Your Honor, we're disputing that it was a safety device in the sense that, well, I guess...
I didn't mean to put you on the spot, but...
No, that's okay,
One
Your
of the
Honor.
questions to be decided.
It's a safety device if it's the sole means.
Well, they couldn't go out the fire escape to do this, right?
And even though the fire escape was there and it was available, we admit the evidentiary
So
record.
if it was a safety device and it failed, obviously, because he fell through the step.
Right.
Why? And it was foreseeable he would be using the stairs because that was how he had to do the asbestos abatement work. Why, as opposed to a 200 claim, which I understand there are different
Sure.
arguments, why wouldn't that be a viable 240 claim?
Well, it's not whether or not it's foreseeable the plaintiff would be using it to access different heights. It's whether or not an elevation-related risk would be posed by the use of the steps. And there's no evidence in the record to suggest that anything having to do with the steps would pose an elevation-related risk.
Counsel, but if you fall off the stairs, you get really hurt, don't you? Because you fall from an elevation. And if you fall through the stairs, it's just as bad, right?
Yes, Your Honor.
Practically.
The risk of falling is always present, but the risk of falling does not convert a fall per se into a 240 violation. The question is, if a permanent part of a building is provided to access from one level to another, is the risk of that device failing to provide protection foreseeable? And here we had a permanent appurtenance, a permanent structure, a permanent staircase on the building that was used by plaintiff himself on several occasions, which no one noticed any problem with. There was no overt signs of any issues with the steps. Plaintiff himself testified he didn't experience any weakness, any movement, anything unusual with the steps going up and down them to perform his work. So the concept underlying...
It wasn't foreseeable. Thank you.
Oh, okay.
We understand your argument, is what I'm saying.
Good afternoon, Your Honors. Peter.
Sorry, go ahead and introduce.
Peter Riegelhaupt of the Parisman firm. Go ahead, Your Honor.
I'm going to to ask you to address the foreseeability issue under the 240 first. How you satisfy that foreseeability issue?
I think, as
Foreseeable risk
Justice
issue.
Gonzalez pointed out, there was clearly an elevation-related risk.
Right, but there is a foreseeability component that you have to see when it's a permanent structure.
Sure.
That it was foreseeable risk of the task performing that would happen. So how did you establish that was separate from whether it was an elevation-related risk, whether it was a foreseeable risk, which is a different question?
We have testimony from the plaintiff who said the building and the stairs were old and in bad shape. We have testimony from Ricardo Blake of PAL who said the building was in very, very bad condition. And I think that's enough. We have photographic evidence that clearly shows, or clearly raises a question of fact, at least, as to the condition of those stairs and what was
So
foreseeable.
do you think we should send the issue of 240 to a jury to decide? If you're saying it's a question of fact?
Maybe I should have moved for summary judgment, Your Honor, but certainly I think the trial
Oh, you didn't
court-
move for some, I'm sorry, I'm getting confused. You didn't move for summary
Not
judgment.
on
It was just
240.
a denial of the 240. So you're arguing that at best there is an issue of fact, and that's
Correct.
probably why you didn't move for 240.
We did move for SJ on 241-6, but did not appeal that.
Right, but you didn't move for summary judgment.
Correct. So that's
But
enough.
even if we found there was a question of fact as to the foreseeability, that would still be a basis for denying summary judgment as to the defendant.
Correct, affirming the denial.
Wasn't there something in the record that there was a claimed abatement in the staircase area that suggested was compromised because of the abatement?
The incident report that was completed by the PAL supervisor, who happened to be the plaintiff's father, which was brought up over and over as if there was something nefarious about it. But yes, there was a reference in the incident report that abatement was done a few days prior.
Which could have compromised the structural integrity of the steps.
And in fact, Mr. Zirkle admitted, of Howell, admitted that structural integrity of the stairs could be compromised in the event that there was abatement. They dispute whether the abatement was done because it's not reflected in the daily reports. There's some testimony that not everything is included in the daily reports. And I'll be honest, if you look at the picture at 964 and 963 in the record, it's clear that the walls in the staircase were demolished, were removed before this accident. So there was clearly work done in that staircase.
I'm looking at the photograph at 1234 of the staircase.
They may be the same, but 964 and 963 are also the photographs.
Before I forget about this, what's your response to the motion as to the 200 and the negligence claims, why they shouldn't be dismissed? Your argument.
Yeah, I think the trial court got it right. Getting back to something Justice Schulman raised, there's no proof that they couldn't have inspected that morning.
They were locked out.
No, they weren't. There's no proof of that. There's no plastic sheeting in that. They were going to they were going to start putting up the plastic sheeting that morning. There's no proof that those stairs
Is there
couldn't.
any evidence in the record that they had access and were accessing that portion of the work?
There's no testimony either way. They weren't denied. There's no proof that they were denied access that morning.
Wasn't work being, PAL was there because asbestos abatement work was going on, or else a PAL employee would not have been there. So we know asbestos abatement work was going on. Normally, I believe one could assume when asbestos abatement work is going on that the owner and other people would not be entering that portion of the building where the abatement work is going on.
There was
That they wouldn't have a duty to go into an asbestos abatement area to go inspect it.
There was no abatement going on the stairs that day. We know that.
But it's in the building. It's not just the stairs. You use the stairs to go to and from different parts of the building. It was in the building.
I don't think, it's almost, you're almost suggesting that a whole class of workers are going to be excluded from the labor law, and that's not the case. Asbestos workers have.
Counsel, I think.
No, I'm not saying they're excluded. I'm saying that I'm talking about 200 liability as against the owner of the premises. The workers are in, but that a 200 claim is different than a 240 or a 241-6 claim.
Absolutely.
You have to show active negligence.
I just think that there's no proof that they could not have inspected that morning. That's all. And the 241-6, the two regulations that are still alive, I think the trial court properly denied SJ on those. And the defendant, in his main brief, completely omitted speaking about one of them. He addressed it on reply only. Thank you.
Again, going back to my earlier comments, I believe there's just issues of fact as to who was responsible for the condition of the stairs, and so under those circumstances, Hal is not entitled to summary judgment on indemnification. And going to the claims of how the accident happened, it's completely contradicted by the logbooks as to what work was performed by PAL at the job site, which detailed on an hourly basis the tasks that they did and doing asbestos abatement work at the site. And none of it, again, none of it mentions the staircase.
Thank you.
Doesn't the incident report mention the staircase?
I'm sorry?
Doesn't the incident report indicate that the step was damaged as a result of the prior abatement work?
There's no indication in the incident report where that information came from, and it's contradicted by the plaintiff's own testimony that there was no work going on in the staircase at the time of his accident, and it's contradicted by not only the logs, but also the safety plan for the site, which doesn't mention any asbestos abatement work on the staircase.
Thank you.
So, thank you.
Taro versus Amade.
Thank you, Your Honor.
Maybe, yeah. Good afternoon, Your Honors. Martin, may it please the court, Martin Schell for the defendants' appellants. Thank you for an opportunity to present to you this afternoon. I'd like to begin. We have basically a shareholder dispute. We have a very disgruntled investor here who invested about $100,000 into this restaurant that operated.
Counsel, what was wrong with the court's order granting an equitable accounting under these circumstances?
Well, certainly you could award an accounting, but the circumstances have to be reasonable. It has to be commercially reasonable. And I think when you have a company that hasn't made any money.
Well, that's your argument that the company hasn't made any money, but there was clearly evidence that substantial payments were made to various parties, not including the plaintiffs. Substantial payments were made out, including the primary member's parents. So why wouldn't those allegations and that evidence be sufficient at a minimum to allow an equitable accounting to take place? Because there could be a clawback if those payments were improperly made. So just the fact that its balance sheet may show it's insolvent doesn't answer the question.
Well, Your Honor, I view this case, should it be, there's certainly avenues of relief for the plaintiff. Could they have brought a complaint for fraud? Could they have brought a complaint?
But equitable accounting is the traditional way that these type of disputes are resolved when it's a limited liability company and where there are minority members. That is the typical route as opposed to a fraud claim or various other kind of claims. So what's wrong with that? The fact that maybe there were other remedies doesn't make that remedy incorrect.
Well, but again, Your Honor, even to get to that point, I think in a way putting the cart before the horse. Could they get an accounting? Sure, they could. I would still argue that it's unreasonable. But just because you get an accounting does not mean my clients are liable for all the bad things that you've said have happened here.
Isn't that the first step, finding out just exactly what the books have to say? I mean, we're talking about a minority shareholder, a non-managing member, trying to get information from the managing members who had control of the books.
Correct.
And over the course of 4 years, the discovery was piecemeal and it still isn't complete. So what's the recourse here? Understanding that the managing members owe a fiduciary, they have a fiduciary duty towards the minority members.
But Your Honor, going back to the cart before the horse.
And can we just also add that there's been repeated refusals to turn over the documents. They were requests repeatedly refused.
I do want to clarify something, Your Honor. There were significant plethora of information produced throughout this 4 years, which is also.
But let's talk about the horse, because you keep
Yeah.
you keep talking about hearts and horses.
Your Honor, I think.
We're all laughing, it's good.
I kind of missed that as I was looking for my next train of thought, so I apologize. But I think there's a process here. You have to come to court and say that I'm entitled to an accounting, assert the allegations
Comes to court when there's no other recourse but to commence litigation.
But you commence litigation and you get awarded an accounting. You don't just automatically get the accounting when you file a complaint. There has to be a decision, an award of an accounting. And there was no actual award of an accounting until 4 years after the case was commenced. During that period of time, we did object to discovery. We did say, and there's case law that says this, you can't just get an accounting right off the bat. You can get discovery that says why you may be entitled to an accounting.
So you're saying that there's no duty to provide an accounting until there's litigation commenced?
No.
This horse is not doing too well right now.
Sorry, Your Honor. You can get books and records from a company. You can get books and records from a company before you commence litigation. That's typical and often the case. But then let's say you need more than that. So
And they got tax records, for example, that showed that all these disbursements were made in much larger amounts than what the plaintiff received, right? Disbursements to the family members who were shareholders, to the defendants, the primaries, and everything.
Let me clarify something, Your Honor. They make the allegation that these were fraudulent transfers, but yet these conveyances were made out in the open, identified on tax returns. If you're going to steal, I wouldn't exactly do it out in the open.
It's not just stealing that this covers. I feel like you're not really maybe comprehending what the purpose of an equitable accounting is. It's equitable to check out what happened in this company and to make sure the outsiders were not treated unfairly. You don't have to show fraud to get an equitable
Agreed, Your
accounting,
Honor.
which seems to be what you're arguing. Why isn't it enough to show all these insider payments were made while the minority members didn't get their payments? So someone should do an accounting and see what happened.
To get an accounting, you have to at least get an award of an accounting.
What's given pretty easily, though?
Trying for a long time to get this information, and it was continually obstructed.
Absolutely, under no circumstances was it obstructed.
No, I'll let you respond to that in rebuttal. No, I'll let you respond to that in rebuttal. You can have time in rebuttal. But you can answer her question when you get to rebuttal.
Good afternoon, Your Honors. May it please the Court. Annie Kubik on behalf of Plaintiff Respondent Mike Taro. I think Your Honors hit all the nails on the head to continue with our sayings. The reality is this. Plaintiff brought this action in 2019. Plaintiff tried for many years before even bringing the action to get books and records to understand what was going on. What he did know at the time was, I invested $100,000. This restaurant grossed $75 million, and I've been paid back $8,000. What the heck happened here? That's the starting point. When we commenced litigation, we tried to obtain the discovery informally. We served discovery requests. We were getting nowhere. We were getting dribs and drabs. We subpoenaed Citrin Cooperman. It took us several years to obtain those records from Citrin Cooperman because under the IRS regulations, defendants had to consent to the disclosure of that information. They refused to consent. We had to obtain court relief. The records we got from Citrin Cooperman show a plethora of misdeeds.
So just cutting to the chase a little bit. They tried to counter you below by saying that there was no pre-suit demand. We know, based on your position, that it would have been an exercise of futility. Bottom line is you want a dissolution, and under the case law, you're entitled to an equitable accounting. You don't need an award, correct?
That's correct, Your Honor. That's actually
And they now have a neutral to try and evaluate this, correct?
correct.
So the issue may be whether they should be paying the fees right now if there's no money.
That's correct, Your Honor. Although we would obviously
I
respectfully
understand.
submit
I
that's
said
not
it's-
an issue, and they should
Maybe,
absolutely.
I said maybe, but that's one of the things that your friend didn't get a chance to raise, but I guess he'll raise it on rebuttal.
Let me ask that question then too. I'll ask you directly. The court ordered for them to pay all the receiver fees, but shouldn't that be part of the overall equitable accounting, and it shouldn't, a determination who has to pay those fees be only determined as part of the overall equitable accounting when there's overall assessment of everything that occurred.
Well, what we're faced with here, Your Honor, is allegations from the defendants who were in control of this company saying, this company's insolvent. It has no money. It, quote, makes no sense to grant this award. So the lower court said, well, it certainly does make sense. And if the company is in fact insolvent, it's because of your doing.
No, the court didn't make any findings. You're suggesting the court made a finding, but the court said, all that an equitable accounting is, allegations have been made. We're going to have that investigated, but no wrongdoing findings have yet been made, and no findings have yet been made as to whether the company is or insolvent. And because no findings have been made, why should the defendant at this point be ordered before those findings are made to pay all the receiver fees?
Well, the finding the lower court did make was, we would not be in this position right now but for your conduct. Your conduct in not producing documents over the course of 4 years. And specifically, I'd like to address documents from 2020 forward, which as of the date
Let me just interrupt, counsel, but you would agree that the appointment of a receiver is not meant to be a sanction, right?
That's correct, Your Honor. We do not concede that that's a sanction.
So the language that you were just quoting does not necessarily apply, right?
Well,
There's been no finding of wrongdoing at this point in time.
That's correct. However, the lower court did say we would not be in this position right now. Had you turned over the documents, we would not need a receiver. The receiver is necessary because you have not turned over documents. Somebody has to figure out what is happening here with this company.
Right, someone has to figure out who pays.
That's correct, Your Honor.
Thank you.
Thank you.
If I may, I agree with the court's reasoning as just talked about.
Don't say that, because we're not holding anything, we're asking questions. So you can't agree with our reasoning, because we're just asking a question.
Right, as in, why aren't you supposed to pay?
Well, because corporations are set up to provide a shield from corporate liability to the owners. There's no reason to pierce that corporate veil, which happened
I'm
here.
not talking about piercing the corporate veil. I'm talking about appointing a receiver. How come if your client has occasioned the need to commence this litigation, why shouldn't your client be held liable, at least at this point in time, for the payment of the receiver?
Your Honor, I'm going to quote, under New York law, for my brief here, under New York law, discovery of fiscal matters and an action for an accounting may not be obtained unless and until plaintiff has established a right to an accounting. This principle has been specifically applied in cases of disputed partnerships.
Right, but what if we say that a right to an accounting has been established?
But that was only established when the court awarded it, which was in December of 2023. Until then, there was no award of an accounting. They could have made a motion from day one.
Thank you. We understand your point. Thank you. People versus Santos?
Good afternoon, Your Honors. Jennifer Klein, appearing pro bono in association with the Office of the Appellate Defender on behalf of Miguel Santos. Virtually none of the testimony provided by the state's expert witness, Hernandez, was legally permissible under ANOA. Certainly, none of Hernandez's testimony with respect to the two key phrases in this case, namely the meaning of 28 and the phrase 300 pesos of the other, was legally permissible, and the verdict must be reversed.
Counsel, you would agree that the so-called prejudice of the expert, as Detective Hernandez explaining to someone like me what chocolate, pesos, 5 fingers, et cetera, if I were trying the case, is not the same as that kind of testimony before a jury. So that the concern about Mr. Detective Hernandez becoming an alleged summation witness, which is what your argument is under ANOA, is of concern here. This was a bench trial. So all that concern and prejudice isn't really there.
Well, it's well settled that judges are not immune to the prejudicial effects of summation witnesses, and judges are certainly not infallible. But the test is whether there is no reasonable possibility that Hernandez's testimony affected the verdict. And here, I don't think it can be said that this improper testimony didn't affect the verdict, given how little evidence exists that Mr. Santos.
Wasn't the someone being watched by the detectives as an exchange? There was a lot of testimony before the court about seeing party going into a car, out of a car, into a home, out of a home, et cetera, and then ultimately where one particular witness was actually caught with the bag of $28,000.
Well, how much?
And all of that, and all of that information or evidence was presented before the court linked to your client, even without Detective Hernandez explaining the jargon or communication from the cell phone exchanges.
So how much money was in the bag? There is evidence, absolutely, that Mr. Santos handed a woman a bag of money, but how much money was in the bag is actually in dispute. That money was never entered into evidence, and no one at trial testified that they counted the money themselves. There is one detective who said he later found out the bag contained $28,000, but actually the evidence in the phone calls on that day indicate that it's much more likely that the bag contained $2,800. Mr. Santos says in one phone call that he made $3,000, which would seem that he's just rounding up from 28,000 or 2,800. I'm sorry. And then the only evidence of a quantity of drugs on November 4th is a phone call involving 50 grams of heroin, and by Hernandez's own testimony, that would be a $3,000 heroin sale. So it's much more likely that the bag contained $2,800. But even if the bag did in fact contain $28,000, there is no evidence in the record what that $28,000 was for. It could be for anything, a non-narcotic. It could be for methamphetamines, which is another drug that is cut by boric acid and lactose that was found in Mr. Santos.
If I understand you correctly, the role of Detective Hernandez in this case was to essentially be an interpreter of certain language that the court might be unfamiliar with, and not to explain what that meant.
Exactly. Hernandez's job was to interpret coded language. That is just language with a fixed meaning within the narcotics world. Hernandez went well beyond that, and he was summarizing entire conversations and interpreting non-code words like 300 pesos of the other. He had already testified that pesos is a common drug slang that means cash or drugs or work. He had no right to testify that 300 pesos of the other meant 300 grams of cocaine when there was no evidence that Mr. Santos dealt cocaine at all.
Was this harmless error? I asked the question because there was a whole lot of testimony here, a whole lot of recovery of paraphernalia. Even there's a question of whether there was consciousness of guilt by virtue of the flight from the police. Given all of the circumstantial evidence, was Detective Hernandez's unnecessary testimony, I'm going to just put it under that rubric, okay? Was that harmless error, or was that pivotal?
No, I think it was definitely not harmless error. All of the circumstantial evidence that you're referring to actually point to much smaller drug sales. Again, the only evidence that Mr. Santos sold any drugs were these calls involving 50 grams of cocaine. The drug paraphernalia found in his apartment also indicates that he sold much smaller quantities of drugs. There were thumb-sized bags found in his apartment, and yet Hernandez was testifying that Mr. Santos dealt hundreds of grams or kilo quantities of drugs. That is not what the evidence actually indicates. That was found at his apartment, or that that the phone calls even indicate. The only quantities that are ever really mentioned are just these 50 grams, not hundreds of grams or kilo quantities. And so, given all of this, it's just very clear that the error was not harmless, that this must have been prejudicial, and that it tainted the verdict.
Why should we reach this since you concede it was unpreserved?
Because in the interest of justice, Your Honor, ANOA was very clearly an important issue for the Court of Appeals. The Court of Appeals made it very clear at the end of ANOA that this was an issue that needed to be taken seriously, that expert witness have been overstepping the bounds of permissible testimony, and that harmless error could not be a way around it, around this holding, and that experts must be reined in and only testify as to the meaning of code words. And here, thank you very much.
Good afternoon. May it please the court. David Gagne for the people. The defendant's claim regarding the expert testimony is unpreserved, and there's no reason to consider it in the interest of justice. As Justice Schulman already pointed out, this was a bench trial, and there's just not the same type of prejudice that would result as if it had been a jury trial. And we know that the judge was not unduly swayed by the contested aspects of the expert's testimony, since the judge acquitted the defendant of the top sale count. But more importantly, the evidence of defendant's guilt, even setting aside the contested portions of the testimony, was overwhelming. It's undisputed that defendant was part of a drug conspiracy in the fall of 2009, and then on October 20th, 2009, he conspired to sell 50 grams of heroin. Just a few weeks after that, Sergeant Daly saw the defendant get out of a car, hand a bag to a woman who he later identified as the wife of his narcotics supplier. He called her the woman of the man that gives me work. And Sergeant Daly later arrested that woman and determined that the bag contained $28,000. So that by itself shows that the defendant conspired to sell well over 2 ounces of narcotics. There was also an incident a few weeks after that in which intercepted phone calls show that the defendant and 2 other men conspired to sell 300 grams of narcotics. So because this was a harmless error, there's simply no reason to reach this in the interest of justice. Thank you.
Thank you.
We do not contest that Mr. Santos may have been in a conspiracy to sell 50 grams of heroin, but that does not change the fact that all of these phone calls, all of this so-called incriminating evidence does not indicate that Mr. Santos was in a conspiracy to sell 2 ounces of narcotics. Again, the $28,000 could have been for a non-narcotic, or it might have been $2,800, which is the only narcotic sale that they can really prove, that the other people can really prove. And as for this 300 grams, this 300 pesos of the other, there's absolutely no evidence that that's for a narcotic at all either. In fact, there's evidence in the phone calls that Mr. Santos was confused by what the other referred to. It could have been for, again, methamphetamines or marijuana, or maybe not a drug at all. But there just simply is not enough evidence in this record that Mr. Santos conspired to sell 2 ounces of a narcotic.
Thank you.
Thank you.
And thank you very much for your pro bono service in this matter. You did a wonderful job. Gordon versus Martell.
Good afternoon, Your Honors. May it please the court, Andrew Jones for Maureen Martell, Administrator for Ronald Hollander, Esquire. This case is plaintiff's after-the-fact effort to look back at a prior litigation against its co-op and see if it can find a way to disperse or defer some of the monies it duly owed the co-op by looking for a way to bring a claim against the former attorney. Now, the only act of claim negligence that is on appeal before Your Honors is that Attorney Hollander failed to correct Justice James's characterization in an order that referred a portion of a hearing to JHO Marin. Now, the claim is that
Is that the last opportunity to do so, though?
I do not believe so. I don't
What
even...
other opportunities would have there been? I mean, I know this is a softball question, but what other opportunities would have been to raise that issue?
I mean, during the hearing, after the hearing, I don't
There
even...
was another attorney already in place at that point,
There was,
right?
and I don't even
So is that your primary argument, that there can't be proximate causation here because even if the claim had merit, there were many opportunities after there was no longer representation where that claim could have been addressed.
That is one of my
One of
primary.
your
The
arguments.
primary argument is proximate causation. Absolutely, I think the big problem with the plaintiff's claim here, looking back, is that they've picked apart some misreading they've seen, and I don't even believe that it was ever excluded. I don't see any sign that anyone tried to correct it, and I do see, we reference in our briefs, some reference to this negligence claim being back in the case afterwards. Also, the causes of action that we're talking about, this is the 8th cause of action out of 8, right? All other 7 they lost on, and they're trying to claim that this 8th one would have been the magic one that would have won the case. And their problem is they don't allege any facts to support why they would have won, how they could have undone this supposed error.
Sir, was there anything in this record that supports their claim that they could have been awarded special damages of about $1 million? There's nothing in the record.
Nothing whatsoever, Your Honor.
The complaint is pretty slim, isn't it?
The complaint is very slim and conclusory. It does contain the buzzwords that you proximately caused me damage, which those words literally appear there, but this court has routinely held that those buzzwords aren't enough. You would have had to allege, the key thing is, let's say that there was an error, let's say that there could have been an appeal. I'm not even sure it was an appealable order.
Yeah, but does it even say how they would have even prevailed in the underlying action?
Correct.
There's nothing there.
Correct. That's the big problem I have with it, is the reasoning as to why JHO Mariam would have granted this negligence claim, which I don't fully understand because it's not articulated. And by the way, none of this is a criticism of counsel. I think he's articulated the claim as best an attorney can. He's just constrained by the underlying record and the reality of what happened here. So he's put forward a claim based on what there is, but the fact that there was...
You're saying that.
Yeah, absolutely. And the claim is that the plaintiff would have prevailed, which is textbook conclusory statement. Last couple of points before I'm out of time. The same applies with respect to damages. The same kind of conclusions apply with respect to causation. And one thing I just noticed is this is the last case on, so I've been able to read the record even more detail. JHO Marin did, there was an abatement issue in the underlying hearing, which for a second, puzzled me. I was like, why did they get some money off? But this is at R98. He's very specific that he's not deciding anything about causation. So he wasn't saying that the plaintiff won that issue. Like they didn't, like he under his reasoning, the plaintiffs could have caused their own loss of habitability. It was just the fact that because they weren't there.
I'm sorry, the major issue was under the Pullman decision, they were terminated because
Exactly.
they didn't let access
Right.
to resolve the leaks that perhaps could have been resolved and not do all the claim damage, correct?
Absolutely, and that was as a result of shareholders voting them to have their lease terminated, which was upheld. So then the subsequent finding where he abated some fees and he knocked 100,000 off the almost 800 that the plaintiffs owed the co-op was just a pure kind of technical, well, you weren't there, whoever caused that. So he didn't make a ruling on that issue.
Thank you.
Thank you very much, Your Honors.
May it please the court, Ian Brandt for the plaintiff respondent. The complaint is well pled, and Justice Kotler got the issue right at the pleading.
What about the issue of proximate causation? Because I'm a little confused by your claim generally, to be quite honest. It's very mercurial, but assuming it is what it is, why couldn't the subsequent attorney have raised this issue, either before the judge, at the hearing, after the hearing? There were numerous instances where this error could have been corrected if there was in fact an error.
Right, so the July 2018 order was a grant of the legal fee portion from the Pullman case and a severing of all the property damage claims to go to Judge Alan Marin for a hearing. My client had 6 property damage claims, sounding both in contract and tort. this court has found that, has held repeatedly, and the citations are in my brief. The main one that strikes out is the Dwayne Reed versus SL Green Partners LLP case that says in property damage, you can have contract claims and tort claims. Now, one of the
But
reasons.
why couldn't that have been brought up? And I don't know that the court actually even made a ruling on this, but if the court made an error by accident, why couldn't it have been brought up at any point in the proceeding? Why?
Because no notice of appeal was filed from.
Right, but there are
that
other
order.
ways you
How
could
else
bring it
can we
up.
do
You could
it?
bring it up that this, since there was never a formal dismissal. It's not like it was litigated and the court said this claim is dismissed. You're saying it was just an oversight by the court, so it could have been corrected at any time by bringing it to the court's attention.
So we did. Motion sequence 37, which I brought by order to show cause in January of 2020. The date is salient for me because it was right before the pandemic. There was a whole series of motions that all the parties brought to get ready for the trial. I brought that motion. I brought a motion under the Liz doctrine, which says that any trial court can review its own orders. It doesn't need to be part of a CPLR 2221 re-argument motion. It doesn't have to be brought appeal. The problem with Mr. Hollander, who I knew, he was a good guy, but he made a mistake here. He filed no notice of appeal from that order. And when I went back under the Liz doctrine in January of 2020, and Justice James had a slew of motions before her, this motion was number 37. It's in the record on this case, and I'll ask the court to take judicial notice of the actual decline to sign, which I have here from 37. Justice James looked at this and said, I'm sorry, Mr. Brandt, there was no notice of appeal filed from this, and from what I can tell, and your time to re-argue expired a year ago. And believe me, when I was looking to try to fix this problem, this was pre-e-filing, right? This is a case that goes back to 2012. The Pullman case went on for 6 years. There was no adjudication at all. There wasn't even discovery of the property damage claims.
Wasn't there another lawyer representing the husband in this?
So Ron Hollander represented Martina Gordon. The husband was pro se until I came in to represent him. And when I was looking at the mistake in this order, which I brought to Justice James's attention. And
At what point was that? Was that after it had gone to the referee? I mean, at what stage in the proceeding?
it was before. So what happened was that the hearing wasn't until September of 2021. After the Pullman appeals were decided, there was a slew of motions brought to Justice James around that time, right before the pandemic. And I argued that the court should reconsider its mistake. And I'll never forget, Justice James, she looked at it. She looked at the pleading. She said the word in the 8th cause of action, the amended complaint, it says negligence. It's joint and several liability against the condo board and the co-op board. It's pled there, but you know what, Mr. Brandt, I'm sorry. There was no notice of appeal filed, and your time to re-argue has expired. That was what the judge said. And it was a important moment for me because I saw the court considered it, but she refused to change her decision under the Liz doctrine. LISS, the Court of Appeals, is a very old case. That was the only thing I could pull out, but my time to re-argue has expired, and part of the point was that no notice of appeal was filed from that July 2018 order. Now, whether we can bring this up under 5501 on the final appeal remains to be seen. There was no notice of appeal filed.
The corollary question is, would you have prevailed?
Sure.
Your clients have prevailed.
Well, we
on
would
the
have had an
negligence
opportunity to
claim.
bring the negligence claim to Judge Marin. And the negligence theory is a different. So in property damage, you can't get personal property losses, additional living expenses, diminished market value, which are pled in that 8th cause of action for investment. Those are not remedies under the contract theories, under the breach of the warranty of habitability and breach of the proprietary lease. And again, I'm referring to the appellate authorities, which Justice Kotler got in her decision. We lost the opportunity to bring all those property damage claims to the court, and I'm able to, again, this is pleading stage. I don't think I need to prove all my damages. We pled that there's $1.45 million in unreimbursed losses that have nothing to do with rent abatement. And I do want to note that despite my colleagues' efforts to say that, they lost this Pullman case and they caused the damage, when we went to my clients are responsible.
Ruling they would have appealed since the court never really made a ruling.
I'm sorry?
What's the court's ruling they would have appealed, since the court never really seemed to make an actual ruling about this? The court didn't say your negligence claim is dismissed, and therefore that created an appealable moment. What was the appeal? From what determination?
From the determination when the
From the
courts-
2018 order,
Correct,
what was the
correct.
appealable issue?
So I believe in the order, the judge cites to, Justice James cites to Article 40 of the CPLR, she says, sua sponte, I am moving to sever the claims, and here are the claims I'm severing. And she identifies the eighth cause of action, she calls a breach of the warranty of habitability.
Right, but it
At
wasn't
that point,
even
Mr.
that a
Hollander
motion
should have gotten
had
up and
been
said,
made that, anyway, let's see if,
But the issue of whether Mr. Hollander, who I knew well, acted with reasonable skill and diligence, he should have said at that point, Judge, Your Honor made a mistake.
you kept
That's a
saying,
negligence
you
claim.
kept
It's
saying
not a
they should make an
contract claim.
appeal. Anyway, thank you.
Thank you, Judge.
Thank you, Your Honors. Respectfully,
So
that-
what's your argument to that, response to that particular argument, that at the point the judge made the oversight, that the lawyer, a reasonable lawyer should have spoken up and said, hey, we have a negligence claim?
Yeah, a reasonable lawyer shouldn't have and wouldn't have and didn't. There was no mistake. There was no error. Let's be clear on that. The reality of it, this is not how we win our motion, but the reality of it is that was no error. That was Judge James making her decision, sending the matter to be resolved. I doubt she even thought about it. I think if it had been raised to her, I think she would have said, sure, the negligence case claim is still in the case. As far as we see, and we refer to it in our brief, the underlying docket 249, Justice James is still referring to the cases containing negligence counts. It's a fiction, respectfully. It's an after-the-fact looking back and saying, "Oh, we could have appealed this and we couldn't get anything in." If you look at the record, there's no effort anywhere by anyone to try to get these issues in before Judge Marin.
So this motion is not in the record that
Correct.
counsel's
None of
referring
that
to?
in the record.
It wasn't attached to these papers.
No,
the
not
prior
in the
motion
papers, not in the
to
pleadings.
bring it before
Right.
Judge James again. He's saying that
I think
he tried
it's-
to bring it to Judge James' attention, but that's not in the record.
And it's not in the papers, Your Honor. I think that it's currently on appeal. The whole case is still on appeal. The ultimate issue. So I don't think, because it's a sua sponte decision, I'm not even sure it was appealable. It was interlocutory in some ways because it wasn't like the whole case was being dismissed, right? So I'm not sure they even had a right to appeal. But really the thing that wins the day for us, which I believe a lot of you have already picked up on, is that let's say they could have somehow appealed it and should have. There's just insufficient proof other than speculation that, well, we would have gone on and we would have won this. It's just not there. It's not alleged, it's not supported, and that's why the case should be dismissed.
Thank you very much.
Thank you.